And here, ready to hear argument on any and all. And so first, let's, if we could have counsel for the record identify themselves, starting with the state.
Good morning, Judge Nathan Wade, Special Prosecutor here. Arguing today will be Mr. Floyd, Mr. Wooten, and Mr. Burnick will say a few things.
All right. Mr. Kucherov.
Morning, Your Honor. Chris Kucherov for Mr. Floyd, and with me today is Todd Harding, Aaron McCullough, and Harrison Floyd.
All right. Thank you all. Okay. So what do we want to start with? Your motions, Mr. Kucherov.
Let's start with the easy stuff, I suppose. Just probably try to get that out of the way, Your Honor, if that's okay. Right, let's start with number one, the motion to unseal and that'll be by my colleague.
It's actually number two, Your Honor.
Number two.
The grand jury transcripts.
Correct.
Okay.
It's a brief argument, as I'm sure you're aware. We're essentially just seeking to have any transcripts from the special purpose grand jury of witnesses that would be called in the underlying criminal case. I think we've been given about 66 thus far. We just want to ensure that we get all of them if they're if and when they become available.
So just to be clear, you've gotten, and it's been represented to you, the complete transcripts of 66 of the
I
witnesses?
believe that's so, yeah.
And I think, I want to say the number that sticks out to me is that there were 74 total witnesses presented. Do you recall?
Sounds right.
Okay. And you think that what you're asking for is, I guess, what, another 8 or so?
Whatever the math is.
Are there any in particular that you think are part of that 8 that are of heightened relevance to you, or?
No,
Okay.
not at this point.
So we had this come up earlier in the case with the co-defendants, Chesbro and Powell. Did you get a chance to take a look at that order?
We did.
So it seemed the statute made it pretty clear that those materials belonged to the district attorney, and I couldn't see anything that suggested otherwise. Do you have anything that suggests otherwise?
Not at this point. Anything we've cited would have been in our brief.
Okay.
And a lot of that relied on those prior filings also. This was filed back in September, so it's an older motion.
Sure.
So
Is there any particular witness testimony that you think might be, you have specific knowledge, maybe Brady material of some kind at this point?
not at this point, we don't.
Okay. All right. Thank you, Mr. Harding.
Thank you.
Anyone from the state on this?
Briefly. Answer any questions you might have, but probably would be asking you to enter an order just consistent with what you had ordered back with Chesbro and Powell. Basically, the transcripts are our property, but if we wish to use any of the witness testimony at trial, we'd have to disclose them in accordance with our discovery obligations. So that's all we would ask for.
Okay. And did we have those numbers right? You disclosed 66 of 74 transcripts?
I don't know the total that's been disclosed. I know that we are still awaiting 4 transcripts from the court reporter agency. And those are 3 troopers, I believe Cobb County troopers or GSP troopers, and then, 3 GSP troopers and Patricia Raffensperger. So just 4.
And just again, for purposes of establishing it on the record, is the state's ultimate intent here to disclose the transcripts of every single witness who testified in front of the special grand jury?
As far as I would, at least every transcript of every witness we intend to use at trial, or that we could use at trial, we would disclose. And that'd be consistent with your order back in September.
Sure. Okay. All right. But for now, again, it seems like you're very close to almost having turned over everything.
Almost, right.
I'm just curious.
And we're just waiting on 4 more.
Yeah. All right. Well, thank you, Mr. Burning. Well, not having heard that there's any other supplemental authority to rely on to compel disclosure of these, I believe I'll enter an order consistent with what I had done back in September. Sounds like the DA has already turned over the majority of these materials. And if there's some specific aspect of them that you think creates a legal avenue for you, feel free to raise that. But at this time, I believe that motion has to be denied. All right, what next?
I think we go to number 7, demurred accounts 1 and 30.
All right. And before I forget, Can you give me an update on where you are with 1 and 3, basically your negotiations with clerk of court?
Working together to try to fulfill it like I would in a civil case, working with the other party, trying to see what points we have agreement on. Got an agreement on the electronic data, just how we're gonna deliver it. My intent was to go and speak with Chad Alexis, who's the county attorney, and have my tech guy talk to his tech guy and effectuate a transfer. My hope is that we can come to the court with consent order, or even to just a protective order that would protect those materials.
And what's your timeline on that?
Your Honor, that's a function of the county. I don't have a timeline on their beck and call, so to say, their mercy. I'm guessing I'd like to have it as soon as possible, because the sooner I have it, the sooner I can synthesize the data and integrate it into my case. But
And well, I just, what I'm thinking through is it's a lot of material. And it sounds like the county, I presume, and you have worked out some kind of terms where the bulk of it is being provided to you, perhaps under the, most likely under a protective order. I don't have any concept or idea of how long it would take you to go through that, or what it is you're planning to do with it. So do you have any, can you enlighten me there?
both of those things,
Well, just what is let's say you get it all today. What is the process that you then do on your end, and how long does that take?
I spend money on a tech expert to distill it, to write an AI program to go through the material, to sort and sift. One person can't possibly go through the evidence that was turned over at the state, let alone going through the election material. They're both daunting in that sense. And so you have to have technology available to you in order to sift through the materials. Otherwise, it's humanly impossible. I wouldn't be ready for trial for 4 years. So that's how we intended it to.
Sure. And so now you've got an algorithm, you've got an expert. What does that look like? Is that something he can just,
Not an algorithm, it's a artificial.
a program
Yeah,
of some
it's a
kind?
Program, right.
Not my area of expertise. How long does it take for this program to run the data?
As you're asking, I don't program. I don't know. I just know it happens.
Mm-hmm.
There's AI programs. There's nothing new in the legal profession. All types of AI programs all over the internet, chat, GPT, and all this kind of stuff. And it does make the workload easier. Can I say how long it takes? Well,
This isn't something I'm holding you to. I'm wondering if you've had ballpark figure estimates, conversations with your expert.
it's the 2 terabytes of discovery we got from the state up to round 6. I can't say round 7 because I don't know what round 7 is. But up to round 6, it probably took my tech team about a week and a half to organize it in order. That doesn't tell me what's in there, but at least I can go in there and recognize what folders are what. And then from that point, I would have to have my tech guy tell me how he would find certain things, or I would ask him to find certain things. Like I'm querying him. He's my live booth.
Sure. No, and that's what I'm kind of getting at is you've got, potentially, tens of thousands of ballots you're getting. I'm curious what that looks like.
Out that way.
Yeah.
He'll write a program and he can go through those ballots in short order. If
Okay.
you're just asking at the ballots, that's quick.
Right. So up to this point, I had no idea whether you were saying you're going to sit there and go through them one by one as if it's a hand audit. Okay. All right. Well, I know Mr. Alexis, I think, is planning to be here this afternoon. Sorry.
There'll be a hand count, not a hand audit.
There you go. So he'll be in the building if you need to see him this afternoon. But you had mentioned number 7. So this is the demurred accounts 1 and 30 filed January 5th. Floor is yours.
Judge. Your Honor, I have 3 points to make. And you need not write this down. It'll be easy. You'll remember it.
That's why we put it on YouTube.
There you go. My first point is that there is no false statement. My second point, they have no false statement. My third point, there will never be a false statement. The indictment claims there is one, but it gives us 0 facts about what it is. I want to stop here just for a moment, and I happened to find in discovery, this is to show you how things are innocuous and you don't necessarily see the significance of them. I was looking for discovery, and I came across a search warrant that Your Honor signed in November of 2023 to obtain Venmo records for Mr. Floyd. And I don't know who's arguing. I'm gonna hand up the warrant to you, Your Honor, and I've got it highlighted. I don't know if you want to see the highlights. You're good. I approach, Your Honor. Sure. Thank you. Starting at the very bottom of that page, the next page. It's not very long. And it's talking about what happened at the Cobb County Police Department. Over the next hour, Cootie, in person, that's Trevion Cootie, she's a defendant, and Floyd, via the phone, attempted to persuade Ms. Freeman to falsely confess to the voter fraud allegations spread by Trump and Giuliani. Later on, it goes, as you can see where I've highlighted, Cootie and Floyd offered Ms. Freeman legal assistance in exchange for her false confession. Ms. Freeman declined their offer. A police incident report was generated, and there is video and audio of the meeting between Cootie Freeman that was held at the police station. I've listened to the audio. I have an audiologist breaking that audio down. We're getting it transcribed. There is absolutely no statement in that video about falsely confessing to voter fraud allegations. There is no statement in that video asking for a false confession. And the court signed this affidavit in November of 2023. But the state was aware of something else, and that is Ms. Ruby Freeman's testimony before the special grand jury. She said during the grand jury testimony, they asked her what was said, and she said, "I'm not a mind reader." And she could only speculate that they wanted her to steal ballots, or they wanted her to say that she was stealing ballots. So nobody knows what it is that they were attempting to, quote, get them falsely confess. And I would submit to you that you were misled, that they have no factual good faith basis to make any of these statements. I've searched high and low through 2 terabytes. And that's just the search warrant. Your Honor, if you look at their pleadings, they don't say they have a false statement. What they say is, we don't have to tell you anything. We've given you detail. We've tracked the language of the statute in a wooden and very perfunctory way. But that's not what the law is. The law says you have to give sufficient detail. My argument isn't that you haven't tracked the statute. It is that I don't have sufficient detail. If you accuse somebody of making a false statement, you at least have to give them enough detail to know what the false statement is. And so why is this false statement so important? Because, Your Honor, it goes to the heart of our defense. If I wanted to say that the statement wasn't false, if I wanted to say that the statement was in fact true, I need to be able to know what the statement is. How can I know that by looking at the 4 corners of the document? I cannot. The 98-page indictment is a sprawling indictment. It goes all over the place. The incident with Ms. Freeman appears to be an isolated incident, a random incident that was just cobbled in and thrown into that 98-page indictment. And if I may, Your Honor, when I ask about the false statement, there's another reason for needing the false statement. If you will look at the Georgia definitions of RICO that are dated 2020, and I just pulled this offline. May I approach, Your Honor? Sure. It talks about, and I'm going to direct you down to 5A, Roman numeral 22. This is what Mr. Floyd has been charged with. False statements in writings or false lien statements against public officers or public employees in violation of Code Section 1610-20. Ms. Freeman is not a public employee. So I guess the charge has to be that they were soliciting Ms. Freeman to make a false statement to a public employee or to some member of the public that has jurisdiction over the matter. Typically, that statute, the false statute you see is when you're a police officer and somebody walks up to you and says, hey, my house burned down. And the officer says, well, what happened? It burned. Okay. Do you know why it burned? I have no idea. I just came home and it was on fire. And the officer later finds out that you burned your own house down because you wanted the insurance claim. That would be a false statement under this section. You made a false statement to an officer. So without knowing what the false statement is, I don't even know if it fits the statute. I could take Mr. Harding out in front of the building and have him write down on a piece of paper and say, Todd, I want you to write down, I am not and never was a U.S. Marine. That would be a lie. He was a Marine. That's not actionable under the statute. Just because you make that's assuming it's a false statement. I don't even know what the false statement is. In other words, I have to know how it's being used. I can't mount a defense unless I know that. And more critically, maybe I want to prove that the false statement is true, right? I mean, it could be true.
So just to be clear, as it comes to count 30, we're talking about a special demurrer, right? You want more detail.
If it's special or general, I still need detail. Even in general, you need sufficient facts to support it. It's not just, you can't just cite the language of the statute with no facts whatsoever. That wouldn't be, otherwise, no DA would ever put any facts in an indictment.
Okay.
Okay, so you have to have sufficient. What does that mean? Do they have to have every little detail? Absolutely not. Absolutely not. They don't need that. What they need is sufficient enough to meet the element of each of the crimes they've alleged. That's all. And as I said, the state's argument has simply been throughout, we don't have to tell you. You know, I thought they were supposed to turn over the defendant's statements. His own statements are those that are attributable to him in discovery, but I keep asking for this and I don't get it. The response from the state is that they don't have to give particulars of overt acts. And they say that Act 120, which is almost the mirror image of Count 30, Count 30 is a conspiracy version of Act 120. But they say, well, Act 120 is an overt act. And they don't have to provide it for the overt act. But the problem is, if you look at the language of the indictment, Act 120 doesn't say this is just an overt act. It says this is a predicate act. If the court took them at their word that Acts 120 and 121 were just overt acts, you can go ahead and sustain our demurrer to count 1, because then they haven't proved the RICO conspiracy. RICO conspiracy requires an agreement or 2 predicate acts. They put those 2 predicate acts in there for a reason. So we're entitled to know the particulars of what the false statement is, because they say it's been completed. They say it's there in Act 120. I want to hear today, I want the court to ask today, tell us what the false statement is exactly, not in general platitudes or they wanted her to falsely confess to election crimes. Which election crimes? What false statements? What was said? Because they don't have any of it. And Judge, what is an overt act, by the way? An overt act is a defendant decides that they want to commit a crime. And the overt act is the action that they take towards making that crime happen. We often describe it as a substantial step or an overt act. Under the case of New v. State, which is a Georgia appellate case from 2004, an overt act can't be just anything. It must be something that's inexplicable as a lawful act and more than mere prep. So a lot of things that they cite, and we're going to go over that real quick. And I would ask you, Judge, to look at their response at page 10. And here is what the state claims it alleges are sufficient facts. Number one, Donald Trump lost the United States presidential election on November 3rd, 2020. They're putting that again at issue. I'm not sure how that applies to the false statements. Members of the enterprise, including the defendant, falsely accused Ms. Freeman of committing election crimes in Georgia. That's not true. I looked in the indictment. The indictment doesn't say that. The indictment actually says members of the enterprise. It says several members of the enterprise. In fact, why don't we just, let me get the actual indictment. Members of the enterprise, this is at page 17, paragraph 4. Members of the enterprise, including several of the defendants, falsely accused Fulton County election worker. It doesn't say that Floyd was among them. It just says several defendants. There's nothing in there that says that Floyd was one of them. These things were repeated to Georgia legislators and other Georgia officials. He didn't repeat those to other Georgia legislators and other Georgia officials. And then once again, they say that he and his cohorts traveled from out of state. He was on the phone to harass Freeman, intimidate her, and solicit her falsely to confess to election crimes, plural crimes, that she did not commit. What crimes? I have the right to know what those, he has the right to know what those are. It may be true. We don't know that yet. You don't get to hide it until the day of trial. I need time to understand what those false statements are. And the rest of this. Members of the enterprise, including the defendant co-conspirators, traveled from out of state to harass Freeman. That's not a crime. That may not even be an overt act. That could be a First Amendment activity. So it's explicable as a First Amendment activity. It says members of the enterprise, including defendant, intimidated Freeman and solicited her to falsely confess to election crimes that she did not commit. Again, we just went over that, but what does it mean, intimidated her? That's in the indictment, but it's unknowable. The Supreme Court of Georgia actually has already talked about the word intimidate being too generic of a term to be able to just lie naked in the indictment without any kind of explanation of how she was intimidated.
Where do you find that?
If I'd had the opportunity to do the brief that I wanted, Your Honor, I would have had all this laid out for you. I apologize. State v. DeLobby. It's 293 Georgia Appellate 723.
Say that last, Georgia appellate.
Correct. In that case, they,
Wait, no, what was the last number?
oh, I'm sorry, 723. I can put this in the post-hearing brief as well. Defendant Lee solicited the defendant, that's Pastor Stephen Lee, called Harrison Floyd, who had been associated, says was associated with, that's right, because at that time, Black Voices for Trump was part of the Trump campaign, and in November it was over, but called Mr. Floyd to assist with his efforts to speak with Freeman. It's public knowledge, Ms. Freeman didn't want to speak to white people. So Mr. Lee calls him. So what? That's not an overt act. That's not inexplicably an overt act to further what? Again, when we think about overt acts, and we're talking about overt acts to further what? We have to answer those questions. As the defense attorney, I've got to know what those are. The defendant attempted to place 2 calls and sent a text message to Freeman on January 3rd. Again, so what?
The defendant participated in at least 18 telephone calls with defendants Lee and Cootie between January 3rd and January 5th. Again, so what? These are all Republicans in a Republican Party. They're all working together. Of course they're talking with each other. Of course they're calling each other. It doesn't make them necessarily overt acts. I'm not saying they can't be overt acts, but it's not clear how these things are being used for overt acts. If we knew what the false statement was and how it was to be used, all of a sudden overt acts start to gain context and you know what they are and what they mean and why they're there. The other thing is the state attempts to say all the time that they agreed. There's no facts of the agreement. There's just a bunch of acts that they claim are overt acts, and they assume that the agreement exists. But I haven't seen any coherent statement on this topic, and in large part because, as I said at the beginning, there are no false statements here. If the state had them, they would have said it. You, Your Honor, should demand that they tell you since you signed that search warrant to effect justice, essentially, you should demand that, hey, look, you represented to me two things in that warrant. First, you said in the warrant that there were false statements. And then you said in the warrant that there was a police incident report generated and video and audio of the meeting. She's careful to say, she doesn't say that she watched that audio and video of the meeting. They just simply put it at the bottom, and that's misleading. It's as though, hey, all of the things that are in this paragraph, there's a video and audio of the meeting. You should be able to, you should ask that senior investigator, did you actually watch this? Where are these statements located in that video? I'd be rather upset if I were a judge and I was told these things, they weren't true.
Well, you'd agree, Mr. Kucherov, there's a way to challenge the veracity of a search warrant affidavit, right? There's a motion you can file. You can get this entire search warrant kicked out if anything in here is.
No, I'm using it as
false,
illustrative
right?
evidence for you, Judge, that you were misled to think there's a false statement. They claim to the world in the indictment that there's a false statement, and there is none. And the point is, they've told you there's a false
I
statement.
understand that's your position, but if that was the case, could we not have a hearing and challenge that?
To what end? I mean,
Get
he
this
doesn't,
entire search warrant kicked out and suppressed.
he doesn't, but the evidence they received, they've got that evidence from another defendant. I don't care about it. We don't care about that evidence. That's meaningless to us.
Okay.
But the point is, it's not about kicking that search warrant. It's about you signing off when an officer comes before you and represents that these facts are true. They're invoking the power of the state. And, you know, he's facing 37 years potentially. They can at least get it right. This is an important case. This is not a vanilla DUI case that might come before you on a regular basis or any other type of a domestic battery or what have you. This is an important case. We should slow down and do it the right way. There's no rush. So I would ask the court to grant our demur, but I'd like to know from them, from their own mouth, what exactly is the false statement that he wanted Ms. Freeman to make, keeping in mind that even Ms. Freeman doesn't know that answer. Thank you.
Good morning, Judge. I'm going to keep this very brief. I'm confident that our written responses address all of the arguments that Mr. Floyd's attorneys have made. I'm confident that their arguments are meritless. I do want to just hit a couple things very briefly. As the court knows, the first step in addressing a demur is you assume all the facts that are alleged are true. And so we just heard about 15 minutes about how the facts alleged in the indictment are false. As the court also knows, case after case tells us that that is what's called a speaking demur. It's void. It's not grounds for dismissing an indictment. Great arguments to make to a jury at trial, but that's not where we're at. We've heard all this stuff about we don't know what an overt act is. We don't know what intimidate means. I don't think that any authority requires the state to append a Webster's dictionary to the indictment. These are common terms with common meanings. So I think that those arguments are meritless, Judge. Mr. Kucherov kind of did some of my work for me. What I intended to do was come up and read off what we had listed in pages 10 and 11 of our, 10, 11, and 12 of our response, which is all of the things that he complains are missing from the indictment. We've listed them out with citations to the indictment as to where those questions are answered. It's our position, and we laid this out in the brief, that we don't have to allege the specifics that he's asking for, because a person could conspire to solicit false statements by getting together with someone and saying, hey, let's just get the witness to lie. There's no talk about what they're trying to get the witness to say, what the lie is going to be. That's enough in and of itself. The indictment alleges that. Again, I think that our written responses address all of these arguments, and I'll take any questions that the court might have.
Well, is there anything that you'd like to add concerning the search warrant affidavit, since that's been raised?
Judge, the only thing that I would add is, again, that's looking at things outside the face of the indictment. It's a speaking demur to the extent that it's even relevant, to the extent that they even have standing to challenge it. They had a motions deadline. They could have filed a motion on that. They didn't. It's being raised here for the first time. I don't think it has any relevance whatsoever to a demur. And so we would just argue to the court that it should not even be considered in the way that it's been raised today.
I want to ask you something generally else that I've been seeing in response by the state to a lot of these special demurrers, which is that you provide a list of what's been provided in discovery and say that can supplement the notice. Is that, you know what I'm referring to there?
Judge, you're referring to some of the filings we made, I believe, on Friday and Monday.
Sure.
Yes.
Right.
Yes.
I don't know if you've done one for this case specifically, or if you were intending to.
Was not intending to for this case. Now, we can do that if the court requests. We absolutely can do that.
Well, I had some questions on it, but I guess if it's not really relevant to this one at all, we can save that for another day.
Sure.
But I guess the core of the argument here seems, well, how about you get into, or maybe this is what Mr. Floyd was planning to do, responding to the issues about predicate act versus an overt act, and some of the matters raised there.
Judge, I'll defer primarily to Mr. Floyd on that. I was a little confused on what the argument was there. I don't think it's raised in the written motion. As the court knows, you gave a continuance to this hearing for them to file any reply to our response. That was not done. So I think, again, this argument's being raised for the first time, and I'm not quite sure what the argument is.
All right. Well, I don't know. Maybe Mr. Floyd wants to jump in and tag team here. I think he might have formulated some kind of a response as well, and I'll pass it back to Mr. Kucherov if we need to.
I'm happy to. Your Honor.
Okay.
The overt act versus predicate act. Subsection A requires a pattern of racketeering activity. That's a substantive violation, not what's charged here. Subsection B requires a pattern of racketeering activity, substantive violation, not what's charged here. Subsection C, what is charged here, requires one overt act by any conspirator to effect the object of the conspiracy. That's the language that's used. And so to begin with, it's important not to conflate conspiracy violations with substantive violations. We've mentioned this a number of times, and I'm not going to belabor it, but the law is very, very clear. It is not a prerequisite to a conspiracy violation that the defendant commit a substantive violation, because otherwise conspiracy would be subsumed within it. They're different things. An overt act, what we often run into, and I think this is part of a legitimate misunderstanding. I don't think it's a contrivance, is we have alleged 161 overt acts. A subset of those overt acts are also acts of racketeering activity. There is nothing anywhere that I have ever seen that says an act of racketeering activity cannot be an overt act. And in fact, when you look at Georgia RICO conspiracy cases like Pasha and Overton, among the overt acts are acts of racketeering activity. In this indictment, when we have alleged an overt act that is also an act of racketeering activity, we have said so. And we've identified where that type of activity it falls within the definition of racketeering activity within the statute. But to say, as I believe I heard, that, oh, that's a predicate act, so it can't be an overt act, that's just fundamentally wrong. It's just not true. The case law federally is very, very clear, and it's relevant here because in 2015, when the definition of, when the verbiage of subsection C was changed to make it clear that there's an overt act requirement, the same language was used as 1648, which is the general conspiracy statute in Georgia, which is the same language as 18 U.S.C. 371, the general federal conspiracy statute, which I'm sure you dealt with in other aspects of your career. And so that does create an express overt act requirement. At common law, there was no overt act requirement, and many federal statutes don't have one. Some Georgia statutes don't have one at all. Its purpose is to show that the conspiracy is in operation, that it's not a mere thought crime. Somebody has done something in furtherance of this objective. But it does not have to be a crime. It can be completely lawful activity. It can even be activity that would be protected by the First Amendment. It need only be in furtherance because its purpose is not to prove a different crime. Its purpose is to show that the conspiracy was in operation. And because a conspiracy is by its nature a partnership in crime, each overt act is attributable to every partner. And I know I've cited it ad nauseum in the past, but Pasha is probably the clearest example of this. Whaley is another clear example of it under Georgia law, where the courts, the Georgia courts have made it very clear, as they have under the general conspiracy statute, that any overt act by any conspirator is attributable to every conspirator.
And so under that metric, an overt act is alleged, is it ever going to be held to the same standard as a standalone count when it comes to, say, special or general demur?
The case law is that it is not. And I mean, there are Georgia cases that actually say the state need only allege that there was an overt act and
Not in detail.
doesn't need to identify it. It is not, overt acts are not subject to the same special demur standard. It is simply something we have to give notice of. Now, we've gone into considerable detail here on overt acts. We've given dates. We've identified who was involved. We have described the general activity, where the overt act is also a predicate or active racketeering activity. The two phrases mean the same thing, just two different ways of expressing the same concept. We have identified exactly what it was. But the fact that we did that doesn't increase our burden. It simply means we went beyond what Georgia law requires and what analogous federal law suggests might be required. But to be clear, federal law, and we cited this in several of our briefs, makes it very clear an overt act need not be a crime. And it in fact can be something entirely lawful by its nature. Just a simple example from another case in this courthouse, renting a car, and that car is used 2 days later in a drive-by shooting. There is nothing unlawful about renting a car. There is everything unlawful about renting a car in furtherance of a conspiracy that includes killing someone. And that is an over. So the idea that, everybody's a Republican or everybody can talk on the phone, et cetera, it just doesn't have traction in the overt act concept. The question is this conspiracy moving forward in any way? It could be buying somebody gas money, giving them a ride, handing them a phone number. I mean, the list really goes on and on. And as I said, here we have 161, we need one.
All right, thank you, sir.
Yes, sir.
And last, just kind of point to probably back to Mr. Wooten. As I see it, the core of defense's argument on the specific motion is, I think we heard it many times here. He wants to know the exact false statement that was solicited. I don't know if that means, a direct quote or just something more specific. And as I see it, the most applicable vermin in the indictment is going to be what you list out as paragraph 13, specifically soliciting her to falsely confess to election crimes that she did not commit. And so the defense puts to you, well, there are a number of election crimes out there, and that confession could have come in many different forms. Why don't you need something more specific?
Again, Judge, the example I gave that if two people get together and say, let's get her to make a false statement, let's just get her to lie, that's sufficient. So if that's all that happened, that's all we have to allege.
Well, his point was, it's lawful to lie. It's only unlawful in certain contexts, right? If it's in the jurisdiction of another agency, if it's the other elements of false statements, right?
Yes, Judge, and the indictment alleges all of those things. I mean, I think where we end up is no matter what level of detail we provide in the indictment, they're going to say, we still don't know. We still don't know. So if we say what crime, they're going to say, well, tell us how she would have committed that crime. And if we tell them how she would have committed that crime, they're going to say, well, tell us when and where and why. I mean, it's an argument that doesn't end, and the law simply doesn't require us to go that far.
All right. Thank you, Mr. Wooten. Mr. Kacherov, give you a few minutes, quick response here. Have at it. Still have a lot of ground to cover.
So I
Sure.
got a little latitude, Judge. I don't know if I could be more clear. I'm not asking for more detail. I just want the false statement to begin with. Mr. Wooten said, it's like two people, and I wrote it down. Let's get together. Hey, let's get the witness to lie. That would be a start. That's not found in our indictment. That they went and they said, hey, let's get together. That fact's not there.
Well, it does say that they're soliciting her to falsely confess. That's to lie, right?
That's not a fact. What he was citing was the two of them get together and say, hey, let's get together and cause her to lie. There's a difference between making an assertion about a conclusion. He made a false statement. You allege that. But that's not a fact. That's not an allegation of fact. I'm looking for the allegation of fact as it pertains to the false statement. What was it? You were on it just a moment ago when we talked about election crimes. What election crimes? You have to be able to give us that context. So I just want to point out, they can't have it both ways. Mr. Wooten says in his demur, or his response to our demur, that they don't, my argument as to count 1, Act 120 is easily dispensed with. As the Georgia Supreme Court held, there is no authority requiring the indictment to set forth the particulars of an overt act. But if you read 120, it says that it is both a predicate act and an overt act. So if it is just an overt act, and I take his word for it, they haven't, on its face, we have a general demur to the conspiracy charge. Why? Because they haven't proved anything. They've got a series of overt acts which are in furtherance of nothing. They're not in furtherance of any particular crime. So that's why those two things are noted also as predicate acts. And I want to just briefly finish up Mr. Floyd's argument about one overt act to affect a conspiracy. I'm not disagreeing with the law on that issue, or what an overt act is, that it requires, it's furthering the crime. But you can't use the First Amendment to commit a crime. The overt act has to be inexplicably directed. It ceases to lose its character as an innocent act and becomes associated with a crime. For instance, Trevion Kuti and Pastor Stephen Lee and Harrison Floyd, if they all got together at a meeting at 3 o'clock in the afternoon on a Monday, and they discussed X, Y, and Z, and that they were going to go talk to Ms. Floyd about X, Y, and Z. We don't know what X, Y, and Z is, but let's assume the indictment says X, Y, and Z. I would be entitled to know that, but I don't even have that kind of detail. All I have, because I looked at the complaint and I said, well, what exactly did Mr. Floyd do wrong? And I can't answer it. I can't even answer my own client exactly. I know they think that he wanted to have a false statement, but they just don't have the evidence. I know they don't. And that's why this indictment reads the way that it does. And so I want to end with just one comment. Renting a car, the First Amendment, true. But if you commit murder doing any of those things, that is an overt act. It's inexplicably an overt act because it wasn't used for innocent purposes. And that's how you know. We don't know anything about this. And I find it remarkable. I've been practicing law for 23 years, done a lot of criminal defense cases. Never once has a prosecutor shied away from saying, it would be in this case, you want to know what a false statement? Here's the false statement. Let me tell you. And at least tell me. They can't even do that. They can't even stand in front of you and tell you. They dance around the issue. And that's the problem with this whole indictment. It's all assertion. Well, they made a false statement. Okay, well, what is it?
Well, isn't that just because it wasn't completed? Because she didn't actually end up making a false statement? And that's just what comes with inchoate crimes? We're stopping short because we don't know what the future would have held. And
How do you know what they wanted her to say? Right?
if the evidence is going to show, I guess that's up to the.
Oh, you just
defense.
said it. You just said it. If the evidence is going to show, well, they have to have some allegations of fact in the indictment to show us just a smidgen of what that false statement would have been. What were they trying to get her to do? I'm going to go up into a jury trial and defend against what? A thought crime? That we think they wanted her to make a false statement? They have no clue. And the reason why they have no clue is because Miss Ruby Freeman has no clue. She told the truth in the grand jury when she said, I'm not a mind reader. They were trying to elicit and lead her with questions about what they wanted her to say. And even she couldn't say it because why? It's not in the hour-long Cobb County video. There's not one shred of evidence that they have, and that's why they dared not put it in the indictment that way, because I would hold them to it. So all I've ever asked for is, what is the false statement? I'm entitled to know that. It's a tiny little fact. That's all I need to know. And they say, well, he's going to want to know more. Nope, that's what I want to know. Thank you.
All right, what's next? All right, so number 6 on the amended notice was general demurs to 130 and 31, and then 8 is a special demur to 31.
Correct. And if you look at the special demur to 31, it's essentially asserting the same grounds as a general demur, but asserting them as a special demur. Talking about the misleading statement. So in the general demur counts 1, 30, 31. There's 3 points that are brought up. I was just going to talk about those briefly. Another court will read these and read the response. Essentially, we're citing in the first point, Johnson v. State. It's cited in the actual motion, so I won't give you the citation. It's in there. Essentially saying that it procedurally fails to provide double jeopardy. All 3 counts in relation to Mr. Floyd. Because it alleges, it doesn't identify some of the parties and some of the conduct that's being brought up in there.
So that's not the first time that's happened before. Do you have any kind of case federally, any state that says the use of unindicted co-conspirators makes something subject to lacking an element?
I don't. But on 2 and 3, others not named as defendants, those aren't indicted co-conspirators. That's different. And also on 3, unidentified conduct within and without the state. I mean, part of the whole purpose of the indictment, as the court's aware, is to give a defendant protection against being tried with the same offenses or anything that would have merged with that conviction or acquittal. When you don't identify the specific conduct, he can't use it in a subsequent proceeding to say, hey, I've already been tried for this and either convicted or acquitted, however the outcome is. So it's a fairly simple argument. As far as the unindicted co-conspirators.
Is that a, well, we can come back to that in a minute.
Sure.
The unidentified conduct. Can you point to me what exactly in the indictment you're referring to there?
Well, they use that similar language to other conduct here in Georgia and without Georgia.
Sure.
It's almost a quote.
That's just in the.
It's in the indictment, yes, sir.
In the count 1 manner and means.
Correct. And then point two, it goes to just count 30. Going to the sufficiency of the substance of the indictment. The case is but Hanny. I hope I'm saying that right. V State. It's cited in the brief. You could look at it. It says an indictment, therefore, is void to the extent it fails to allege all essential elements of a crime or crimes charged. Smith v. State, an indictment is insufficient as a matter of law if the accused could admit all the facts of the indictment and still not be guilty. Essentially, what we're arguing here is the GBI is listed as the agency that would have had jurisdiction. Our contention is the GBI in 2020 at that time did not have jurisdiction. If you read 35-3-4 2020, there's nothing in there that says they had jurisdiction to look at election crimes. And then there's a change in 2022 in 35-3-4. It's going to be paragraph 16. Again, this is in the brief where if they are specifically given authority to look at election style crimes.
So setting aside election crimes, I think the state responded that GBI has the authority to look into generally identity fraud. How do you respond to that?
Well, that's true. The issue is though, is count 30 doesn't state or plead any type of crime like that. Count 1 talks about that, but count 30 is just saying they a conspiracy to solicit false statement. So there's not an identity question in count 30 is what I'm getting at. To where maybe in count 1, if somebody voted illegally or something like that, somebody's identity may be at issue. But in count 30, that's not the case. This is specifically about Miss Ruby's statements. And more to that, it's not an extrinsic question of fact. Jurisdiction is a question of law, Judge. So you look outside the four corners, but you don't look at other facts. You just look at what the law says. So it's not a fact question. It's a legal question, and the court can determine a legal question. Again, they cite 35-3-4A, A11, which is the identity violations in Article 8. That doesn't apply to counts 30 and 31. Additionally, they cite 35-2-33A, 2A. Nothing in 30 or 31 occurred on state-owned property. The meeting was up at a law enforcement agency outside of this county, number one, and then it wasn't on any state-owned property. So that authority is eliminated. You drop down to 35-3-4A16. It gives lawyers authority upon request, but lawyers don't do investigations. And the statute says is within the jurisdiction of for investigative purposes is what they're talking about. So I think those could be eliminated along those lines.
All right, well, let's start there. I think that's enough to unpack, and then I'll
Yes,
put it
sir.
back over to you. Mr. Wooten, will you handle this again?
Yes, Judge.
Why don't we start right there? Would you agree with me that general demurs have been decided before as a matter of law?
Yes.
So why would, if there's an allegation that something was within the jurisdiction of an agency, and as a matter of law, there's no possible way it could be within the jurisdiction of that agency, could that be a general demur in some?
I think in
Hypothetical.
some world that's not this indictment, yes.
Okay. So when we're talking about count 30 and 31, these are all the ones that relate solely to, these are substantive counts that relate to, excuse me, maybe not 31. Yeah, 30 and 31 that relate to Miss Freeman. And they didn't take case on the grounds of the Capitol. I don't think they involve identity fraud as alleged. What is this? Is the sole jurisdictional hook for that to be within the jurisdiction the 35.3.4A, the within, if there's a request to help outside law enforcement?
Well, Judge, I think it could be any of the three, and that's to be proven at trial. Again, going back to the first question in a general demur is, can you admit to all the facts as alleged and be guilty of something? And the indictment alleges that the statements that were solicited were within the jurisdiction of the GBI, of the Secretary of State, and of city and county law enforcement agencies. And the first thing that my friends on the other side stood up and said was that the statements are not within the jurisdiction. So they're already voiding their own demur by challenging the factual allegations. They're asking for a trial. I think even, number one, I think at trial we will prove that the statements that were conspired to be solicited were within the jurisdiction of the GBI through one of those laundry list of ways that we list in our response. But also, we allege that they're within the jurisdiction of the GBI, that they're within the jurisdiction of the Secretary of State, and that they're within the jurisdiction of county and city law enforcement agencies. And as the court knows, the state can join multiple ways of violating a statute into one count. We've only got to prove one of them. So even if they're right, it doesn't matter at this stage.
Right. I just wanted to push on this a little bit because I thought it was interesting. Jurisdiction upon request. It's not alleged, and it doesn't appear that the evidence may be that there was any kind of request on the front end for this. Is that fair to say?
That's not alleged, but again, Judge, we don't believe that that's required to be alleged.
Sure. But it is asserted in the response as a jurisdictional hook. And so I'm just trying to make sure I understand this. Are you saying that a request would not have to come first and that the GBI just generally is going to have jurisdiction over everything just in case a district attorney asks?
What I'm saying, Judge, in the response is that these are the multiple ways at trial that we can prove it, that we have options to prove that these solicited statements were within the jurisdiction. We don't have to set forth in the indictment what the evidence at trial will be. And so I didn't go that next step because I don't think it's relevant to this issue, how we intend to prove it. That's not what a demur is about, but these are the possible ways that we could. And if their argument is that there's no way, no legal way whatsoever that we could ever substantiate this allegation, they're just plain wrong.
All right. So let me take it back to you, Mr. Harding. They point out that it's not just about the GBI. They've alleged it also involves Secretary of State. And then generically county and city law enforcement agencies. But your critique seemed aimed primarily at the GBI.
Well, it's the same argument with the Secretary of State, Your Honor. I
Okay.
mean, as far as the crimes that the SOS can look up, there's a specific section in Title 21, Chapter 2. I think it's maybe Article 15. It's the last section in that gives the crimes and who can investigate those and charge them. So we think that would also be applicable. In addition, it didn't happen in this county. It happened in DeKalb County, the meeting at least. So we would say that as far as what was going on there, we don't think that any of those activities would have been criminal. So we don't think it would have applied to that either.
But that would take evidence to prove, right?
That would.
All right.
The latter part.
Okay. Mr. Wooten, anything else generally you want to respond to in these two motions?
No, Judge, I think we've covered it. Again, I think our written response addresses all the arguments. I don't think there's any merit to them, and we'll take any other questions that the court may have.
All right. Thank you, sir. All right. What next?
I suppose we can do the lack of agreement, number 5.
There it is.
Judge, our argument is that the state and the indictment that the state put out does not allege anything showing that Mr. Floyd knowingly and willfully joined a conspiracy. The word willfully in Black's Law Dictionary means you knew you had a legal duty to do something or not to do something, and you did it anyway. That's what willful means. There's no facts alleging that. They just assert that he knowingly and willfully joined. It's easy to assert things, not easy to have just a sufficient number of facts to show that.
Okay, so you want more facts?
Correct. That's
All
one
right.
thing I want.
All right.
They have to have sufficient facts. That doesn't convert this to a special demur necessarily. Remember, a general demur requires not just simply tracking of the language of the statute, the elements. You have to have a sufficient number of facts to support those elements. Just a bare bones. It doesn't have to be a lot, but you have to have something.
So I know you said that before. I don't know if I'm following you there. What,
I can do that in a post-hearing brief. I mean, I will
Okay.
put this in a brief.
because they seem to, the distinction's been, this has been addressed before. The difference between a
I
general and
understand it's
special
confusing.
demur.
Yeah, it's confusing, but it doesn't really matter whether it's general or special. I want I want to know. In other words, I have a right to know these facts in order to formulate a defense. I have to be sufficiently informed in order to be able to formulate a defense for Mr. Floyd.
Sure. There's a different standard, and different kind of analysis. I think that would, and that's why the distinction matters. It's a bit antiquated, but I think that's where we are still. But all right, so you say just saying knowingly and willfully is not enough.
Right. How does a state prove conspiracy? Well, they have to show an agreement and an overt act. If it's a RICO conspiracy, they show an agreement and that Mr. Floyd agreed to commit or committed two or more predicate acts. So what the state is doing, its whole argument here, it's not that he affirmatively agreed. It's that his agreement is shown by the two predicate acts in counts 120 and 121. Some of this will spill over into the pattern argument I have. So this is Act 120 and 121, Your Honor. Two dots. Is that a pattern? Does that show an agreement? The other problem with this lack of agreement is the cases which talk about the single transaction defense. And again, probably some of this will be covered.
I think it sounds like you're spilling on into it. So why don't we just?
You want to go into it?
I
We
mean,
can go into
it
it.
sounds like the
Okay.
exact same argument you put in
Right.
there. So why don't we just do that?
Well, in Overton v. State, it's a 2008 case, which was decided after the 2001 amendment. I don't know if that jogs your memory about the 2001 amendment. They found that the activities the defendant engaged in were sufficiently linked to form a RICO pattern, but sufficiently distinguishable so that they were not mere single transactions. Here, this is one incident, just one, at the Cobb County Police Station. And they created two predicate acts out of it. It's really the same side of the coin. It's two different sides of the same coin, which is what the court in McGinnis v. American Home Mortgage talked about. I thought the analysis in the McGinnis case was very good because it talks about what the 2001 amendment could have done. And I'm going to go ahead and backdoor into some of the argument on the Constitution, or what I would call the vagueness of RICO. When you look at the act, it says you have to engage in at least two or more acts of racketeering and furtherances of one or more incidents, blah, 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 as long as it's not an isolated incident. One is by definition an isolated incident. So it's kind of hard to say that the single transaction defense isn't available when the statute reads that way, that as long as it's not an isolated incident. There's no other fact in this complaint that connects Mr. Floyd to anything else, or this complaint, I'm sorry, the indictment. There's no other allegation that connects him to anything else other than this Cobb County Police Department.
And do you think that applies with just as much force when it's a conspiracy allegation, conspiracy RICO?
Sure.
When we heard Mr. Floyd say earlier that they don't need to allege or show the completion of any predicate acts whatsoever.
Okay, let's back up. We're talking about agreements. We have illicit and licit agreements. We're talking about illicit agreements. It's not hard. Two people get together, they want to plan something. How do you prove they made that agreement? That's the purpose of the overt act is once you know, hey, those two conspired, did they commit an overt act in furtherance of it? Doesn't matter whether they completed the crime or not. What matters is that they agreed.
Sure.
And how do you show that? Words, conduct, deeds, actions, and an overt act. So there, if we had an intercepted phone call where he said, hey, I'll use his example. Let's get somebody to lie about X, Y, and Z. And you've got the phone call. How are we going to do it? Well, drive to the corner of Main and F and sit there for an hour and wait for so-and-so to leave the building. And the guy who drives to that corner, he waits an hour and he gets cold feet and he leaves. I would say you can charge that. Why? There's the overt act. But you also have the agreement. You can't have the overt act without some kind of an agreement. The agreement tells you whether the overt act is inexplicably an act in furtherance of the crime as opposed to something like a First Amendment activity. So there are no affirmative allegations that he affirmatively agreed. There is a conclusion that the state alleges in the indictment that he knowingly and willfully joined a conspiracy, but there are no allegations of fact to support that. And so they're left with Act 120 and 121. And that's just for count one, the RICO conspiracy. With respect to the conspiracy in count 30, which is the sister of the 120, I would call it the sister count. Again, I don't know what statement they conspired to make. You can't just say, well, they traveled to go out of state. They recruited somebody to come out of state. For what? Those acts are not, they're explicable as normal, ordinary day acts that everybody does all the time. But the question is, what is the agreement? And the other thing is this, to what end? What were these things supposed to accomplish in terms of the crime? We don't know. If I knew that kind of stuff, if the indictment alleged those bare minimum facts, we would know. So without going further, I don't know if the court wants to hear from the state on that, but I can go ahead and do unless you want me to go into the constitutional argument.
I think, yeah, okay. I think it's probably better to split it up. So we'll pass it on over.
Okay.
Presuming that's Mr. Floyd again.
Then that's my cue.
All right. So, all right. So as I hear it, now we're focusing on the agreement, what level of detail needs to be alleged regarding the agreement. And I think we started getting into, 2 acts versus 1 incident, et cetera.
Yes, and I'm going to try to untangle this because it's tangled. And I said a few moments ago that a violation, a substantive violation of RICO, A or B, is not a prerequisite to a C violation. Okay, that's just the distinction between a substantive violation and a conspiracy. One thing that illustrates that simply is obviously an A or a B violation could be committed by a single individual acting alone. They would not have to have any cohort. There would not have to be any overt act. They could decide they want to murder people. They go out and they murder 2 people. Those acts are related. That could be under some circumstances sufficient. Okay, so they're different offenses. And part of the problem that we're running into here is that these are being mushed together. And the time and time again, either expressly or implicitly, the argument on behalf of Mr. Floyd, I have to keep this straight, the other Mr. Floyd, is the one over there, not me. We'll call him the party. Is an argument that basically says the state can't prove a conspiracy until it's proven a substantive violation. That is not true. That is directly contrary to the text of the statute. It is directly contrary to the United States Supreme Court's ruling in Salinas, Salinas, a case I think we cited in most, if not all, of our briefs. Salinas made it very clear that a defendant can be convicted under RICO of conspiracy without violating the substantive statute. And what made that clear is Mr. Salinas was a chief deputy sheriff in Texas. His boss was a gentleman named Marmolejo. They were both charged with RICO substantive and RICO conspiracy by the federal government. They went to trial. Marmolejo was convicted of both. Salinas was convicted of conspiracy only, acquitted of the substantive charge. The court affirmed the substantive charge. The exact argument that you just heard was the argument on behalf of Salinas, which was that he has to either engage in a pattern of racketeering activity or agree to commit 2 acts of racketeering activity. Rejected. The court specifically said, we cannot require 2 acts or agreement to commit 2 acts by the defendant as a prerequisite to RICO conspiracy liability. That argument was adopted by the Georgia Court of Appeals in Falaci versus Columbus Bank and Trust. That is a case that binds, Your Honor. There is nothing that overturns it. And the language in Falaci is express. It cites Salinas. It quotes Salinas. It adopts Salinas on this point. There's no way to tease out of Overton or out of some passing reference in another case and dance past Falaci, because Falaci is Salinas and Salinas kills that argument. And so we are plain and simple, the state is not required to prove 2 predicate acts or agreement to commit 2 predicate acts as a prerequisite to Mr. Floyd's liability. That's been said at least 3 or 4 times in the course of the 2 arguments you've had already. It is dead wrong. We do not have to show a pattern as a precondition to agreement. There is nothing in subsection C that suggests that. There is nothing in Georgia RICO conspiracy law that suggests that. That is just not the law. That is just made up. And Salinas and Falaci refute that. The real question here is, could Mr. Floyd admit the allegations and still be innocent? And the answer is emphatically no. Now, the other mistake and fundamental assumption and error in the argument you just heard is, and this stems from the idea that we have to prove a pattern individually against Mr. Floyd himself in order to prove RICO liability for conspiracy. That is also dead wrong. I'll also go to Falaci. Falaci says there is no requirement that every defendant personally engage in a pattern of racketeering activity. And Pasha tells us there is no requirement that a defendant in a RICO conspiracy personally commit even 1 overt act. So the comment that you heard several times, well, if there's anything wrong with 120 or 121, Acts 120 or 121, then you can just grant the demur, could not be more wrong, and flies directly into the face of the binding precedent. Mr. Floyd does not have to commit any overt act to be liable. We have 161 overt acts by 19 different defendants here. No argument, no variation, no extrapolation of anything they've said eliminates 161 overt acts. They haven't even talked about the overt acts committed by the other defendants. Pasha makes it abundantly clear that 1 overt act by any one of those other defendants is sufficient to sustain a conviction. And so they're just missing the point. The whole premise, assumed premise of their argument is that Mr. Floyd is charged with a substantive offense. He is not. and that we must prove a substantive offense by Mr. Floyd against Mr. Floyd before he can be liable, responsible for a RICO conspiracy violation. Both are just absolutely dead wrong. And both are contradicted by cases that bind Your Honor. That just doesn't get him there. And we've heard a lot about what's missing. Let's talk about what's in the indictment. What's in the indictment are dates and places. And you heard descriptions of Mr. Floyd's conduct as if he were just some lonely sojourner who popped up in Atlanta because he just happens to be affiliated with one party versus the other. That's not what the indictment says. And that's not a fair reading of the indictment. He is alleged to have engaged in 8 overt acts. Every single one of those overt acts involves him acting or communicating with another defendant in this case. In the course of these, most of them involve 2, and some involve 3. I'm not counting the unindicted co-conspirator, that would take it to 4. So we have him acting with Lee, with Cootie, with Schaefer, and with Cheeley. He's nothing he is alleged to have done does he do by himself. Everything he is alleged to have done, he does in conjunction with at least one other defendant. And it's not like he's just randomly bumping into people at a cocktail party. These are the same folks. There's a core group here, and it's part of one of the 8 categories of conduct that we identify in the course of the means and methods section of the indictment. It is focused on Ruby Freeman, and it is taking place, again, facts we can't ignore, at a particular time and in a particular context. And as I heard my opponent say, context matters for overt acts. Well, the context is that most of these contexts, first of all, we have 3 people traveling from out of state to come here, all trying to contact Freeman. That's Lee, that's Cootie, and that's Mr. Floyd. Okay. We have repeated efforts to contact her, and when one doesn't succeed, the other slots in as part of the same effort. But it's not as though Lee, for example, just left Georgia. He stays involved. He just can't obtain the direct contact. Okay. And so they are working as a team. They are talking to one another, and they are doing it on the eve of the electoral count. 3 days, 2 days before that. At a time when if Ruby Freeman popped up and was successfully convinced to lie and say, yes, I manipulated votes. Those weren't breath mints. That was a thumb drive. I did scan the documents. There's half a dozen things she could have said that would have been a jackpot for them.
Are those the false statements? I just want to know.
I'm not answering counsel's
I'm sorry, I
questions.
apologize. I just want to know if those are the false statements.
Yeah. And all right, fair enough. Let's take that point on. All right. Challenge accepted. As you pointed out in Coet Front, right, they didn't need the full menu. They needed anything because the game was, and when you look at the other overt acts that are alleged to be taking place in exactly the same time frame, another part of this conspiracy is unfolding in Washington. And that is the part of the conspiracy that's intended to convince then Vice President Pence not to count certain electoral votes, to reject them, or to take other action that would have the same effect so that President Biden would not be certified as having been elected. I mean, we're talking about within 72 hours, 48 hours. So there is context, and context does matter. This is not just a random visit from the welcome wagon where suddenly three people from out of state decided they needed to just come to Georgia, and the person they had to talk to was Ruby Friedman, someone they'd never met, never heard of before these accusations were made against her by Mr. Giuliani and Ms. Ellis and others. So context does matter, and it is not as isolated as is being portrayed. One of the crucial factors, I heard a reference to double jeopardy earlier. Could they assert double jeopardy? Well, the overt acts, although we're not required to, they certainly take care of that one because you've got dates, you've got people, you've got places, you've got activities. Right? Can we pop up 2 years down the road, 3 years down the road, and come after Mr. Floyd for these same telephone calls? They're identified by time, person contacted, the exact sequence. Double jeopardy is taken care of. There was a reference to single transaction. And that popped up for the first time in the brief that was filed at 11:08 Saturday night on behalf of Mr. Floyd. So let's take that one on. Prior to 2001, there were a number of cases in Georgia that looked at RICO substantive and said you can't count under some circumstances, either you can't count an event as 2 different acts, or you need more than one incident to support a RICO. Some of that was imported from federal decisions in other parts of the country. In 2001, the last expression of that was the Clark case out of the Georgia Supreme Court in 2000. The General Assembly didn't agree. The General Assembly, you remember, because we've had discussions about this, said this statute will be liberally construed. And the Supreme Court had imported an extra textual requirement to limit the scope of the statute, and the General Assembly didn't like it. So in 2001, the General Assembly amended the definition of pattern and said one or more acts, I believe it's incidents, schemes, or transactions. The statutory language will make it clear in the event that I have slipped on that. But the point was, one is sufficient. More might be stronger, might be better, but one will do the job. For reasons I can't explain, both some Georgia courts and some federal courts just missed it. Just missed the fact that the amendment had taken place and continued to cite old case law. This got fixed in 2016 in a case called Mbigi, M-B-I-G-I, in which the Court of Appeals recognized the 2001 amendment and said, yes, 2 acts for this, I'm talking of a substantive RICO violation now, 2 acts that are related in furtherance of one scheme are sufficient. Laid this to rest. There's a curious coincidence here, because you heard my brother refer to the McGinnis case in the 11th Circuit. McGinnis and Mbigi were decided on the same day. I believe it's March 2016. So each was decided without knowledge of the other. Right? But Mbigi's the one that counts because Mbigi binds, Your Honor, the 11th Circuit does not. And so and I'm looking for the district court site that addresses this. Excuse me just a moment. In the course of, so what happens is that McGinnis also misses the amendment, and McGinnis goes on to cite old Georgia cases which had been negated by the 2001 amendment. It doesn't address Mbigi because Mbigi, it's not aware of it. The two cases are basically being birthed at the same moment. So what's happened as a result of that? My opponent likes McGinnis and complimented it. That's great. No Georgia case has ever cited McGinnis or relied upon it. The Northern District of Georgia has looked at this situation in a case called Newton versus Bright House Life Insurance Company, 2021 Westlaw 2604654, which was decided March 11th, 2021. Judge Amy Totenberg. And Judge Totenberg looked at this and said, well, what do? I have these two cases. And her conclusion was, as McGinnis is not binding authority on the interpretation of a Georgia statute and its reasoning is inconsistent with the express language of the statute, the court declines to follow McGinnis as a basis to dismiss plaintiff's RICO claim, and she went on to apply Mbigi. So the single transaction argument is that's no good anymore. It's gone. It's actually been gone since 2001. But Mbigi and Newton make it clear that it's gone now, which is what matters when you're deciding it. And respectfully, I don't believe the court has the option of rejecting Mbigi from the Georgia Court of Appeals in favor of McGinnis. That's one is binding, one is not. The main point on agreement, though, turning back to what I think was where we originally began, the Georgia law on this stacks quite high. Conspiracies are by their nature, in most circumstances, surreptitious. The actual agreement does not even have to be spoken. It can be tacit. And because of that, juries are allowed and courts are allowed to infer the existence of an agreement from the behavior of the parties and the other circumstances that are there. The state does not have to prove or show an agreement in the indictment. What the state has alleged is a circumstance. First of all, we expressly allege that Mr. Floyd did willfully and knowingly join. We've tracked the language of the statute. We've actually gone beyond the language of the statute because knowing and willfully is not in subsection C. We have described the objective of the conspiracy to unlawfully overturn the election. And we have shown actions that were taken by he and his co-conspirators to achieve that objective. That is absolutely sufficient. And you could throw out every single overt act we allege about Mr. Floyd. I'm not suggesting that would be correct, but to illustrate the point, if they all disappeared, we would have 153 other overt acts, any one of which would be sufficient and none of which does Mr. Floyd attack. And so we don't have to prove the substantive violation. The arguments about the sufficiency of predicate act versus overact as to Mr. Floyd are irrelevant here. They're sufficient, but they're also irrelevant because by themselves they wouldn't do the job. It is not, they are acting as though the only overt acts alleged in the indictment are the ones alleged against Mr. Floyd. And that is manifestly not the case. And therefore their arguments, even if they were right, would fail, but they are not right. I guess we're going to move to constitutionality.
Sure.
Yep, certainly.
I'm sorry to interrupt your arguments.
My friend and I could not disagree more. Everything he just told you is not my argument. Okay. He said if we strip away
But even look, even if we get into the weeds of which case got it right, which one didn't, what can you say to the fact that McGinnis is the one? You can say it didn't in your brief. You say it didn't look at the statutory text. It didn't go far enough. It was, you say it was poorly reasoned, but that's the Court of Appeals, and I have to do what they tell me. What do you say to that?
They didn't say that. I think that what I say in the brief is, let me put it this way. Let's put McGinnis aside for a moment. Our duty as judges, as lawyers, is to look at the words in the law and expound on that text. That's what we're supposed to do. You know, the old sayings that Chief Justice Marshall said, you know, we have to, that's the purpose of the judiciary, is to expound on the law. And so when we look at that statutory text at the very end, it says, as long as it's not an isolated incident. You know, so you're going to have to interpret that regardless of the McGinnis rule, regardless of all these cases. And that's part of my objection to RICO, is it is a case by case basis on RICO, which makes it so subjective. And we'll get into that. But let me move on. My friend told me, or told us, that we could strip out all of the allegations, the predicate acts, the accounts, the overt acts in the complaint, and there would still be 153 overt acts that he had not objected to, because he's not linked to them. You strip out those what's linking him to the fact that he's a Republican? That's all that links him. My colleague also tends to harp on the fact that, oh, there's this act, there's this act, there's that act. But what I'd like to do is go back to first principles and go back to the rules. Pardon me 1 second, Your Honor. And the rules are what is required to prove conspiracy. Vanilla conspiracy, not RICO conspiracy. You need an agreement and an overt act. Clear. For RICO conspiracy, you need an agreement, and I want to read to you what the courts have said. An agreement can be shown in either of two ways. By showing an agreement on the overall objective, that is, I believe their overall objective is to overturn the election, even though Georgia only has 16 electoral votes, so I'm not sure what they'd be overturning. But it can be shown in one of two ways: by showing an agreement on an overall objective, or by showing that a defendant agreed personally to commit two predicate acts, and therefore to participate in a single objective conspiracy. So that's why those two predicate acts are located in count one. They have to have them because they have no other agreement. They have no other way to show agreement. The agreement is the precondition. It's the condition preceding to one of those two ways. I don't understand the argument about Salinas, because that's not my argument. Salinas was decided in 1997. There's hundreds of cases which say what I just told you, and I can enumerate them if you'd like. But it's not about overt acts. Overt acts are innocuous in one sense. We look for those things to show a furtherance of the objective, going to the objective, not the agreement itself. Mr. Floyd is trying to use those to show an agreement. And I suppose in some sense I can't discount that you could look for an overt act and there could be an inference that it showed an agreement. But if we stick to the rule and we look at the facts here in this case, in this indictment, there is no agreement. There's just phone calls, and they're talking to Ms. Freeman. I suppose at base it could be an agreement to talk to Ms. Freeman. But then we get back to my question where I heard the words challenge accepted, and what did we hear for a false statement? Nothing, because they don't have it. The MBG case, the civil case, McGinnis, some of these, they're civil cases. And I know we look at the RICO statute in both contexts, but I think when it comes to a criminal case, you have to be very circumspect because it's different. We're taking a man's liberty, his life away. And so as I look at the statute itself, that's my problem, is that it doesn't say anything about the single transaction being removed. Mr. Floyd came up and told you about the 2001 amendment. What is the proof that that's what the General Assembly addressed? If you look at the case that I cited, in my brief. The federal case, I raised it, the McGinnis case. If you read it, that judge does a reasoned analysis of the text. It is inescapable. I would submit to you that if the Court of Appeals saw that similar reasoning, the Court of Appeals would say, yes, that's correct. They'd have to reconcile, I suppose, MBG in the other cases, but this is undeniable. And that's really what precedent refers to. So we don't just uncritically defer to precedent. We have to look at what precedent is telling us. Look at the logic. Does it apply to our case? And that's really what the issue is. The 2000 case of Overton talks about it because the Overton case is addressing the statute as it existed after 2001. Now, some can say that's an oversight, but I would submit, Your Honor, that when they say that these were sufficiently distinguishable so that they were not mere single transactions, that goes to the very end of the statute. And I want to read the whole statute. The statute tells us or commands that a definition for a pattern of racketeering of activity means engaging in at least 2 acts of racketeering activity in furtherance of one or more incidents, schemes, or transactions that have the same or similar intents, results, accomplices, victims, or methods of commissions, or otherwise are interrelated by distinguishing characteristics and are not isolated incidents. How is this incident at the Cobb County Police Station not an isolated incident? There is no other method or commission in the indictment that shows anything remotely similar. Now, in the beginning of the discussion, I held up my pad with 2 circles on it, or 2 little dots. And I asked the court, does that equal a pattern? And I could do the same thing. We could do it all over. You've done this in school when we were kids. I could do an X, I could do an O, I could do a dot. And we would never think for a moment any of those things formed a pattern. And so that's the problem with this statute is asking you to make that pattern. It doesn't explicitly say what the pattern is. So with that said, at this point, I would like to go into the other argument. That's okay with you, Judge. Mr. Floyd wrote, and I appreciate his work, so what he wrote, and I hate to tell you, Mr. Floyd, I was not a lawyer yet when you wrote your first book.
Thanks for that.
He says, despite its fundamental importance in multiple attempts by the Supreme Court to explain what constitutes a pattern of racketeering activity, the boundaries of the federal pattern element remain elusive and subject to inconsistent interpretation. 12 years later, he wrote in his second edition something very similar. Despite its central importance and multiple examinations by the Supreme Court, the exact boundaries of the federal patent element remain uncertain and subject to inconsistent application. I would submit to you the same is true here. And Scalia is the first one that raised this in the Northwestern Bell case, but he did it in a very quick manner. He had not given a lot of room to it because what was before him at that time was continuity plus relationship. I don't know if you had a chance to read my brief, Your Honor, but you already ruled continuity as no part of Georgia's RICO pattern definition. All of the cases that, and I won't torture the court, but all of the cases that were cited in my colleague's brief, I went through every single one of them, all 56 that were cited in the exhibit. They were all continuity cases because continuity is what defines the pattern. They use continuity plus relationship to define the pattern.
Well, also because that's what was at issue in Bell when Scalia is referring and making this quote, right?
Right.
So that's the only thing they're litigating federally. We're not litigating that in Georgia because we have a completely different versus requires. So
here's the
how
problem.
do you bring this home to the Georgia statute, this argument?
Exactly. So I'm not, so I'm trying to bring home, I'm not going to try to bring home his argument. His argument is that the federal statutes they give a backhand to all these cases. Let me start by saying this. The courts typically do one of 2 things. Either with remarkable reluctance to overrule a statute, or through utter cowardness, they will either treat these as an as-applied challenge, or they will. Give me 1 second, Judge. I've left my. They treat these as an as-applied challenge or an uncritical reliance on precedent, without even looking at precedents. A lot of the cases that my colleague cites, they're footnotes. So-and-so raises an objection. This has been ruled upon. We're not going to, we're not even going to pay attention to it, and they slap it down. Or they focus on due process issues of the predicate offenses, and they find that the predicate offenses are unconstitutional. I think it's high time that a court actually give the words context and meaning. The RICO statute was intentionally written abstractly because the notion is that the common man thinks that way. Well, if you tell the common man to go get pizza, he'll go get a pizza. If you tell him to get a pepperoni pizza and he comes back with an all-veggie pizza, we look at him and go, what are you doing? Well, you said you wanted a pizza. No, I said pepperoni pizza. Words have meaning. It can't just be vague things that mean nothing. The state so that I can either hand up to you my versions of the 56 cases, or you can take my word for it, and I'm sure my colleague will agree to me. They refer to the continuity argument. And the way to bring this home to answer your question, the continuity argument to define pattern there, the reason why the courts are wrestling with it is because how silly is it for a court to say that continuity plus relationship is unconstitutional? It's a Supreme Court judicial test. So they were stuck. They bound themselves into a corner in the federal sphere. But Scalia noted, to him, that phrase was about as helpful as the phrase, life is a fountain. And I agree with him. And he then looked at the text and briefly paused and noted he couldn't believe somebody hadn't attacked the text yet. And yes, what happened after Northwest Bell? There was a smattering of cases that attempted to attack the text, and no one wanted to bite on it. That doesn't mean that we shouldn't look at it. I mean, slavery was around for hundreds of years. It was wrong the first day it was made a law. It was wrong the last day that was overruled. This is a case that I would submit to Your Honor if you look at the actual words, and I'd like to turn to that first of the statute. And we start with the very first phrase, engaging in at least 2 acts. This was the one that Scalia talked about, where he said, what does that mean? It tells us what is needed, but not what is sufficient. And when I drew those 2 dots on the page to show you, even you would concede that's not a pattern. Now, I could draw 2 dots, draw another 2 dots, and draw another 2 dots, and maybe that would create a pattern. I could do a series of numbers, 1, 3, 5, put a space, add the number 9.
Well,
You'd fill that in as a pattern.
You're making the Bell argument, I think, exactly as articulated. And I can understand the point that we shouldn't blindly defer to precedent. Sometimes things need to be reconsidered. I'm just not so sure this is the court that has the ability to do that. Vagueness has been addressed before with its exact same language.
No, Your Honor. Vagueness has never been, there's no case, not a single case that has addressed this argument. Not one single case.
The argument just
The text.
about what a pattern of racketeering means.
What
That's the vagueness.
What this text means. There is not a single case that does a textual analysis of what this statute means.
Okay, now
There are courts.
that's a distinction. They may not have done it well or done it as in depth as you'd like, but to say that no case has ever addressed vagueness of this exact language in Georgia, isn't that a bit accurate?
Objectively, no case, not the way I would like it, but objectively, no case has done any kind of textual analysis on the statute. There is a conclusory.
But they've issued a ruling, a conclusion.
Absolutely, I'll concede that.
Okay,
But they're not that many.
even if there's just one, what am I supposed to do with that? According to the code, I have to follow that.
You have to follow the precedent if it matches this case. If it matches this, I would submit to you those facts are much different than these facts here. But as we hit each part of the phrase, and I'm not going to go, if you've read in my brief, I drill down on each part of the phrase. I attempt to extrapolate on every part of the RICO statute because it's not possible to know what it means. Indeed, we alluded to one earlier when we said engaging in at least 2 acts of racketeering activity in furtherance of 1 or more incidents, schemes, or transactions. 1 or more. And then the end of the statute says what? As long as it's not an isolated transaction. Well, wait a minute. Isn't that confusing here? 1 or more? Isn't one transaction by definition an isolated transaction? I would submit to you that the reading here is not easy. And the other thing is, when we talk about the part of the definition that discusses the interrelated part, things that have the same or similar intents, results, accomplices, victims, or methods of commitment, or otherwise are interrelated by distinguishing characteristics and are not isolated events. This is ambiguous and vague for any number of reasons, but what interrelated or methods of commission or otherwise? Otherwise what? Where do you find that language? And if the court's going to deny this demur, then at least we could note these points as being problematic and that they should be addressed by the higher courts. Because how is the man of ordinary intelligence supposed to know any of this? How is he supposed to know what 1 or more transactions mean if at the end of the sentence it says, as long as they're not isolated transactions? And that brings us right back to the single transaction defense. So my argument is that the statute is vague, it's ambiguous, that it doesn't afford the common man of common ordinary intelligence the ability to understand the charge, which is why I ended up with the quote about Caligula when he created his laws, and there was like such a clamor for them. But unlike Caligula, who had his laws way up high in the corner where nobody could see them because he knew his laws were clear, we've accomplished something that not even Caligula had thought of, which is to bring the law 1 foot away from one's eyes, whether you're a lawyer, judge, or a common man, and it still find it vague and ambiguous. And so with that, I will reserve my time for rebuttal.
Thank you, sir. Mr. Floyd, any Roman analogies to deploy as well in response? That could be a good challenge.
I do.
All right.
I do have.
Let's start there.
I hate to disappoint. So, since you asked, and this will be brief and hopefully not too terribly painful. The actual statement in the brief was that what the General Assembly has done would make Caligula blush. I have to disagree because they cite Suetonius, and one thing Suetonius makes it clear is there's nothing that can make Caligula blush. On top of that, neither Suetonius has never been cited by any Georgia court, and Caligula has never been referred to by any Georgia court. So I think we can set that aside. And just to close out the Romans, this is a lot more like Justinian. The code is out there. It's written down and anybody can look at it. So moving on to this millennium, the brief starts out by quoting, well, me. And I'm not sure I want to be in the same company as Caligula, but we're at different ends of the brief, so I won't take offense. Nothing in the language that's cited from either edition of my book suggests that I think the federal RICO pattern definition is unconstitutional or the Georgia RICO pattern definition is unconstitutional. And it is a well-established fact that the fact that courts disagree about how to interpret a statute does not make it unconstitutionally vague. Courts disagree about the application of statutes all the time in specific cases, and that is simply not an argument that supports it. Neither is an abstract, hypothetically driven argument. You heard a passing reference to as-applied analysis. That's what applies here. And that's something that's important to keep in mind. Again, I think the argument ignores a number of binding Georgia cases, and I've mentioned them before, so I'm not going to belabor them. But Pasha, Falaci, and Falaci citing Salinas all make it clear that the argument that Mr. Floyd keeps going back to, whether directly acknowledged or not, is that this case hinges on the states proving he individually engaged in a pattern of racketeering activity as a prerequisite to liability, and that's just dead wrong. And there's no dancing past that. The attempt to elevate Justice Scalia's concurrence to the pole star here, to the thing that should drive all analysis, it's a noble effort, but it just doesn't get the job done. Justice Scalia wrote his concurrence in 1989. No court of appeals, federal or state, no, not the United States Supreme Court going back to it, not any state Supreme Court has bitten. That gives us 25 years in which no appellate court has found that argument persuasive. And there's no reason to find it persuasive now. And to be fair to Justice Scalia, that's a gentleman with quite a reputation. People paid a lot of attention to what he wrote, but this never made the cut. And there's a reason. The constitutional challenge, first of all, it's dicta. And so let's be very clear. The idea that this somehow impels Your Honor to examine this question, quoting Justice Scalia himself, no constitutional challenge to this law has been raised in the present case, and so that issue is not before us. Some courts declined to follow it on the basis that it was dicta, but many went through the analysis and just simply said, we're not persuaded. He clearly feels strongly about it, but we don't join with him. 3 years after his concurrence, the Ninth Circuit noted in United States versus Dishner, 974 F. 2nd, 1502 at 1508, vagueness challenges to RICO have been uniformly rejected by this circuit and every other court that has considered the issue. Fourth Circuit in Bennett the following year observed that all of its sister circuits uniformly rejected vagueness challenges. And let's be clear, Mr. Floyd has not cited one appellate case from any court in the United States, federal or state, that has held a pattern definition unconstitutional. He hasn't cited one case that holds a similar statute like the continuing criminal enterprise statute or Vicar unconstitutional. Cases statutes that incorporate many of the same concepts. Hasn't worked there either. Every state that's looked at this question has rejected it, including states with pattern definitions closer to ours than the federal. Again, not a single decision of a state appellate court holding a pattern definition unconstitutional. The breadth, we keep hearing overbreadth, overbreadth, overbreadth. But, it is extraordinarily rare for a statute to be struck down on overbreadth. I can't remember the last one in Georgia. A similar argument was made in the Rodriguez case 20 some odd years ago to challenge the Gang Act, and that failed. That would be the most analogous one. It failed in Chansey with a direct challenge to the pattern definition here. Chansey is a Georgia Supreme Court decision, rejected the challenge. The Supreme Court has given us some guidance, US Supreme Court, in the application of the vagueness doctrine. It is not designed to convert into a constitutional dilemma the practical difficulties in drawing criminal statutes both general enough to take into account a variety of human conduct and sufficiently specific to provide fair warning that certain kinds of conduct are prohibited. That's Colton versus Kentucky, 407 US 104 at 110. As the Fourth Circuit put it, a statute is not unconstitutionally vague simply because potential uncertainty exists regarding the hypothetical reach of the statute in question. That's Bennett, 984 F. 2nd, 597 at 605. That was a RICO case. And we have the argument that persons of ordinary intelligence can't understand this definition. Well, the Fifth Circuit expressly held they could in 1976. Okay, United States v. Hawes, that's Hawes, 529 F. 2nd, 472 at 479. It did it again in 1981 in United States versus Uni Oil, 646 F. 2nd, 946 at 953, holding RICO's language is more than sufficient to give a person of ordinary intelligence fair notice that his contemplated conduct is forbidden by the statute. Since H.J. Inc., the U.S. Supreme Court has shown no appetite to examine this question and has actually referred to the, and I'm quoting, clear but expansive language of the statute. The clear but expansive language of the statute. That was Boyle versus United States, which Your Honor has heard me reference many times before. And so what that takes us to is there's a brief attempt, a flirtation with taking shelter under the First Amendment by Mr. Floyd, because that would not restrict him to the specific facts of the case, but that doesn't work. The conduct that Mr. Floyd is accused of is not protected by the First Amendment. Alvarez in the United States Supreme Court makes it clear. When we're looking at conduct that basically deals with untruth, here we're talking about getting someone to make a false statement or ultimately testify falsely as a witness. There's no First Amendment protection for that. There's no First Amendment association protection when the purpose of association is criminal. When we talk about persuading people to make false statements to government agencies or testify falsely, the Supreme Court has described that as being at war with justice. In Re Michael 326 U.S. 224 at 227. That is not protected. In Georgia, Haley versus State, 289 Georgia 515 at 528, the Georgia Supreme Court looked at false statements. That's exactly one of the things we allege Mr. Floyd solicited from Ms. Friedman as being a lie that threatens to deceive and thereby harm the government, which the state may lawfully punish. So the First Amendment doesn't give him shelter. We are talking about circumstances that relate to government functions, not just speaking in the park, giving an interview, or having a podcast. As the Supreme Court said in California Motor Transport versus Trucking Unlimited, 404 U.S. 508 at 513, misrepresentations condoned in the political arena are not immunized when used in the adjudicative process. So that takes him out of that. And then we get to so then the question is this statute vague as to Mr. Floyd's alleged conduct? Because that's really the question for any overbreadth analysis that could be applicable to him. So the breakdown, as I understand it from the brief and today, is that the idea of reference to the first clause in 16-14-3, 4A, engaging in at least 2 acts of racketeering activity. As Your Honor recalled, the distinction between the federal statute requires and Georgia means, and what the Georgia courts have done with that. The idea is, as I understand it, that by saying at least 2 acts introduces ambiguity. The problem is that ignores the binding case of Dorsey versus State, which expressly holds that 2 related acts are sufficient. That removes any ambiguity. And of course, Dorsey is binding. So it's not a question anymore. We look at the text, but we also look at the text as interpreted and applied by the appellate courts of Georgia. Secondly, furtherance of one or more incidents, schemes, or transactions. That's asserted to be vague, except Mbigi takes that away and says 1 is sufficient. More simply means there's more. There's more evidence. But it's not like there's a big question about whether it's 1 or something else, because in both the first clause, I said Chancey, I meant Dorsey, excuse me. And in the second clause, Mbigi tell us 1 is enough. There's nothing to worry about there. Okay. Then we move into the relatedness definition, right? And Justice Scalia wasn't happy about that in his concurrence in H.J. Inc. because it was actually not in the text of the federal statute. It was imported from another part of the Organized Crime Control Act of 1970, and he didn't like that. That was his first complaint about it. And secondly, he said he didn't know what it meant. Well, he said what he said. Nobody else has ever said that. This language tracks that federal provision that was imported by case law into federal RICO. The Georgia General Assembly codified it. Many of the opinions dealing with overbreadth arguments and specifically vagueness arguments, have looked exactly to this language to say this makes the statute less vague because it provides a series of examples, a series of limitations. And it says it's not just enough that there be 2 incidents, but they have to be related to each other. And it gives a series of examples about how this would be related. And if you're going to read it, you have to read it all. So my colleague referenced the word otherwise, but didn't mention the words that follow are interrelated by distinguishing characteristics. That's a limitation. That's a clarification. Are not isolated incidents. His argument is that Mr. Floyd, what Mr. Floyd does is an isolated incident. Well, for the reasons I mentioned before, it's not. Everything we allege he did as an overt act, he did with other defendants. Every one of them was aimed at the same objective, Ms. Freeman. That objective fit squarely within the overall objective of the conspiracy. There's nothing isolated about any of this. The only way to reach that conclusion is to not read the indictment. And so on these facts, as applied to Mr. Floyd, there is no ambiguity in that provision. We've already covered the single transaction arguments, but I won't repeat that for Your Honor. Specifically as to the requirement, as to the argument that the language dealing with relationship between the acts, same or similar intents, results, accomplices, victims, or methods of commission. Courts have looked at that again as clarifying. I have found no decision that holds that as ambiguous anywhere, that says that's constitutionally vague, unconstitutionally vague, excuse me. And there is no case reported in Georgia in which either of our appellate courts have expressed any confusion over the meaning of that provision, have expressed any doubt over whether it is vague or overbroad. They have applied it without difficulty since that clause was first enacted. And it has, to my recollection, it has not changed, or at least has not changed materially since it was enacted in 1980. And so the Georgia provision is not vaguer. The federal provision isn't vague, and the Georgia provision is not vaguer than the federal provision. The invitation to you is simply to ignore the decision in Chancey upholding constitutionality, to ignore Mbigi, to ignore Dorsey, and to ignore a host of other cases in Georgia, to transform a conspiracy charge into a substantive charge so that the defendant can attack it as being inadequate, which is just, frankly, just a ruse. The idea is to attack the charge we didn't make by trying to make it into something else. That doesn't work. I'm happy to answer any questions, but otherwise, I think that gets it.
Thank you, Mr. Floyd.
Thank you, sir.
Mr. Kuchera.
Just a slight correction, Justinian is not Roman, he's Byzantine. And in book 1, he talks about vague and ambiguous laws. Couple quick points. I think it's necessary to kind of go quickly through what I call the en masse cases that the state puts together. Few of them address Scalia, even those that are after Northwest Bell. There's some that he quotes are pre-Scalia. I call them the pre-Scalia cases. A lot of them have zero, if you look at them, there's zero textual analysis. These courts are inundated with the creation of federal crimes, and they're inundated, so they're not, I guess they're not spending the time to do the textual analysis. But a lot of them have nothing to do with the argument that I've asked this court to address. So for instance, the First Circuit, rejection of vagueness challenge to continuity plus relationship test. A loser. Why? They're not going to address the court's own balancing test as being vague, constitutionally unvague. Wouldn't make any sense. But that was the First Circuit. There was 2 citations to the rejection of the continuity plus relationship test. 2 rejections of the challenge to that test. The Second Circuit, excuse me, I was a faux pas. The Second Circuit, the rejection of vagueness because the defendant had sufficient notice. Another case, rejecting the quote unquote assertion that RICO pattern and enterprise are vague. Mentions Scalia, zero textual analysis. Another case in the Second Circuit, I'm going down all the cases, and I can hand you.
Did you reference this and you explored this in your briefing that was on this issue, right?
I did not show you, I went through every single case that he.
So you've asked, well, how about we do it this way? You've asked for the opportunity to submit some
Post
supplemental
hearing.
briefing.
Correct, I'll
Why
do
not
that.
attach that as an exhibit?
And I'd rather do that than sit here and
All right.
expound on all this stuff.
Okay.
But essentially, all the cases they do, like I told you from the very beginning, it gets rather aggravating because you read the opinions of men wondering what are they saying, and only to find out that they've either turned the vagueness challenge into an as-applied challenge. And don't get me wrong, I'd be grateful for a ruling on an as-applied challenge from this court in my favor. Or they rule that uncritically they rely on precedent without even looking to do any sort of analysis, or they focus on the due process issues of the predicate offenses. But not one case, I don't know of a single case where certiorari was denied by the United States Supreme Court to vagueness of the pattern element, as Scalia has suggested. Another thing to consider is this, you can cite case after case after case, but judges do different things. But not in Georgia and a lot of other states that I've been in, it's a textual approach, which is, it's the most fair because that's the rule of law. And Georgia doesn't look to things like picking and choosing legislative history, right? I mean, what we look at is the text itself. We try not to engage in judicially created tests, balancing tests, because we assume that the text that the General Assembly passed is balanced, unless we know otherwise. The vagueness doctrine, just to point out to the court, there's two components. It's not just fair notice, but it's to stop the arbitrary enforcement. And the problem with the as-applied challenge, to me, that demonstrates arbitrary enforcement. Because if all these cases are handled on an as-applied basis, it means we've gotten to the point where we are second-guessing the prosecution's determination that RICO applies. And I have a problem with that. He talked about the Alvarez, US v. Alvarez. That was the stolen valor case, if you recall. And during that part of his argument, my friend said that he would have, that they would want to have Miss Ruby testify. I just want to clarify for the court, nowhere in the indictment does it say they would have Miss Ruby testify in anything. Again, we can say all these things are all speculative, but that doesn't appear in the indictment. I'll end with one problem here. One or more incidents versus not an isolated incident. Doesn't that create a question of what's prohibited? If we want to talk about an isolated challenge or isolated incident, isn't the Cobb County Station 1 hour long interview in a police station where 3 unknown people come to meet somebody else they don't know for an hour at a police station? Isn't that an isolated incident? How does that relate to any of this? I would suggest, Your Honor, that the correct ruling on this, if you're going to do an as-applied challenge, that you would find that this is an isolated incident, that it is really the same transaction, which is 2 sides of the same coin. If you're going to do that, if you're going to rule against the demurrer altogether, I would ask the court to at least conduct a textual analysis, find problems that you think that are appropriate with the text, and allow us at least a certificate of immediate review to address these issues. In the meantime, I'll reserve the rest of my arguments for my closing post-hearing brief.
All right, and Mr. Kishore, to that end, when would you like to have that submitted by? And I'll just note, since you raised the point, it's not about rushing, it's just about being efficient. I've got 200 other defendants. I've got 30 of them facing murder charges, much more liability exposure than this case. 9 of them have been in jail for over 1,000 days. So I've got other things I have to handle as well. And when we have a month's notice that we're going to reset it, I've got to stick to that so we can make way for everyone else in line.
Judge, I appreciate the court's resources, and I have the same issues with my other cases as well. So 15 days.
All right.
Okay.
And you want to have a calendar, what would that put us at? We'll just say March 1st thereabouts, if that's a weekday. What is that, a Friday? All right. And did the state have any other briefing they wanted to do on this?
We like the opportunity. I'm not sure we'll take it, Your Honor, but rather than come back and bother you again to ask for it, if you give us this now, and if we conclude we don't need it, we'll lighten your load.
Okay, we can just follow that up.
Same 15 days, Your Honor.
It's through email. Sounds right.
Thank you.
Okay, so I think we'd also, just the last thing for Mr. Floyd this morning is I'd received a motion to modify the bond. And I think we can take that up as well.
Your Honor, in the last hearing, we had the revocation of bond. My colleague wrote the motion to review it. You said we could bring back the review, and we're bringing it back. Why did we wait several weeks? I wanted Your Honor to see that Mr. Floyd follows directions, and he does so very well. I think now is the time to modify those conditions to allow him to speak freely. And I would suggest that the right approach is to say, you may not address these people directly. You can't use tags in Twitter because it could get to that person and you know that it can. So no tags in Twitter, but he's free to speak his mind, knowing that that's his right, whether it's advisable or not, that he can do that on Twitter as long as he doesn't engage any other co-defendant directly on the merits of this case. Now, the other issue that my colleague raised was this is, he's a member of the Trump campaign. So he can't talk to his own boss?
So that's news to me. That was a flag I'd highlighted in your motion. Can you expound upon the idea that
idea is
affects
this.
his work?
The idea is this, the way the order reads now, it's almost like a no contact.
Sure. No, it is.
Right.
It's not like it is.
I should say,
So
yeah.
so what is his work that isn't being impacted
So-
by this?
One moment. He was reminding me of a conversation we had where he engages with senior advisors, but right now he's been cut off because he can't talk to the senior advisors because he can't get a message to Mr. Trump, or he can't talk to Mr. Sorry. Right. And Georgia, Mr. Floyd was telling me that Georgia has the highest percentage of African Americans, and that is his role is that community. And so he can't do any work with the campaign that way.
When
He
you
has to
say
cut off.
work, though, as I took that, it said to work and provide for his family. So I got the impression he's getting paid for this.
Campaign worker, yes.
Okay, so he is currently signed up and being paid as a campaign operative of some kind, or that's the anticipation that
That's the anticipation. He can't do it right now because there's a no contact order. And I didn't want to take the risk that if he talks to a senior advisor, the senior advisor then talks to Trump, that somehow the state will come back and say, whoa, 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 that was indirect communication. You know, I think what we need to do is focus on making this about this case, communications about this case specifically, not about other matters. One of the objections I had last time was I didn't know who the witnesses was because at that time I didn't have the witness list. Now I know there's 150 witnesses, some of whom we didn't even know. You know, some of the unindicted co-conspirators, he had to go, whoa, we're talking to these people. We need to back off. Who are these people? So I think that it's way too broad. I think we can narrow it down. And I think basically what we're asking the court to do is to allow Mr. Floyd to use Twitter to speak his mind about this case and how he feels about it, not to disparage any other defendant or co-defendant, and to allow him to discuss with some of the people who may be unindicted co-conspirators or quote conspirators, things that pertain to his work or matters outside of this prosecution.
Okay, so I'm open to considering the balance we have to strike between what are reasonable restrictions and the realities of where we are in the coming year. I hadn't gotten the impression in the motion, or now I'm learning it now, that it's not so much that he's just trying to speak his mind on Twitter or any other platform just about current events, which is, I think, something he enjoyed doing, maybe even made a living off of, I don't know, through some kind of engagement. But now I'm hearing it's a little bit further than that. He's actually wanting to get back into campaigning itself. And I think we can talk through that. But I want to explore one more aspect while I have you. You mentioned that you asked that he needs to be able to be in touch with other co-defendants.
He may come in contact with them, Your Honor. He may.
Have you actually identified which ones are also currently working and he would actually have a likelihood of being in touch with?
Not yet, but I know some. The answer is I know some of those are communications I'd rather not discuss out in the open. But those networks that the people that he talks to and uses are there.
Okay. Does Mr. Floyd have any other source of income? So how's he currently supporting himself?
Is working full time. But he does receive disability from the Marine Corps, but that's.
Okay. All right. Anyone from the state?
Judge, briefly, what it sounds like is Mr. Floyd is asking the court for permission to engage in the exact same activity that has gotten him here today. The problem with changing specifically the conditions, in terms of the contact with the co-defendants, they all have the same provision. No contact with any of the co-defendants, Judge. So the state absolutely, positively, vehemently, objects to a change that would allow Mr. Floyd to have any contact with the co-defendants.
Yeah, Mr. Kucherov, I don't think you're going to get me to cross that bridge of just opening it back up to any currently indicted co-defendant. What I was willing to consider and still explore with you is his ability to comment on current events. And so,
Because we're not asking permission to engage in the exact same activity that he was before. That's not what we're asking to do.
sure, that's not what I said, right?
Yeah, that's not what you said.
Okay. But so when we talk about paragraph 5, no contact with any co-defendants, witness, or any person specifically named. First of all, I think you have a valid concern of, well, how do we make it explicitly clear of what is a witness in this case?
So the Gabriel Sterling, I had no idea he was a witness here.
I'm running with you here. And so to provide fair notice of what could be a violation, I think we need to make that somewhat explicit. I don't know if that needs to be attached as an exhibit. Again, this was one that was presented to me as a joint order. I'm trying to clarify and make sure that if this comes back to another revocation hearing, it's explicitly clear what was prohibited. So have you been provided with a witness list of some kind in this case?
The last witness list we've received was about a month after the revocation hearing, I believe, in discovery.
Okay. And turning it back to the state is when you say any witness, with that list of witnesses provided on X date, and I might ask you to look up what that date is just so we'd have a point of incorporation. Is that the list of witnesses that you would think would be comprehensive?
It is, Judge.
Okay. So what I would suggest to make this crystal clear would be whenever we're referencing witnesses, it would be as provided by the state on X date. And you can tell me what that is, and then you can be able to show at any revocation hearing exactly what list was provided and what names were on it. Does that make sense? Do you happen to have that date handy? I think that's something you can follow up with.
We're looking it up, Judge.
Okay.
I think my client's adamant that co-defendants can talk, they just couldn't talk about the facts of this case. I think the intent is that they don't collude.
That is the ultimate purpose behind a bond condition. The fact that it goes much further is recognizing the practical realities of policing that.
So in practical realities, to be real world practical solution, if we have a need, we can come back and address it with the court at that time. The only need I see is perhaps for him to, if he's a senior advisor in the Trump campaign, to be able to speak with the president, that would be okay for him to do, provided he didn't discuss the terms of this case.
Well, and the fact that no one's going to be privy to that conversation and there's really no method of oversight, I don't think that's something we're going to be able to allow.
The old order that you had, paragraph 6, the defendant shall not communicate in any way, directly or indirectly, about the facts of this case with any person known to him or her to be a co-defendant in this case, except through his or her counsel. So it's just about the facts of this case.
All right.
That's what I'm asking the court to go back.
Mr. Wade, any response to that? The original consent bond presented by the state in defense for, I think it had similar language for each defendant. Did it not tie it to the facts of the case?
So that was one of the reasons why the court instructed the parties to come together to sort of clarify that old order, Judge. There's no practical way of monitoring that. He has a private Twitter. He has the opportunity to block whomever he chooses. There's no way that we could monitor those things, which is why we came together collectively and changed that.
So all the other defendants can do it, but he can't.
Well, all the other defendants haven't towed the line and had to be here for a revocation hearing. I think we can distinguish between the conduct of them.
I could go and show disparate treatment, what all the other folks have said, but the real issue is, what I think the court took objection to in the revocation hearing was his use of tags in the tweets. If that's the case, we can police that all day long. They'll know whether he's used a tag or not.
Right.
They want to muzzle him, they don't want him to speak about the case.
I'm also still not, I'm hearing, I'm not really hearing anything definite about why this is such a compelling need at this point. It's possible he may need to speak to co-defendants. He may have a role in the campaign. I'm not really hearing exactly with definiteness what's going on here.
He can't pursue his chosen profession.
Well, no, he can. There's certain aspects of it that he has to be walled off from. There's nothing preventing him from being a campaign operative in this, and from being a very effective one. If they want to use him, he can still speak.
No longer be Black Voices for Trump, because he would have to have some ability to get a message back to a supervisor or a manager, who would then have to take it back up with the boss. And the boss hears it, boom, that's communication. That's any communication. That's the problem. So maybe we can limit it to just that he can have contact with in that respect for work purposes. There wouldn't be very many. Yeah, basically an incidental contact. And then the ability for him to get back on his social media. This also impacts his ability to raise money, because the court essentially silenced him and he obeyed the court's order. I think enough time has passed where the court can see there hasn't been a single incident raised by the state. So there's no cause not to do this. In fact, Judge, he lives out of state. And his ability to fundraise for his defense has gone down since this transpired.
Okay. Anything else you want me to know, Mr. Kuchera, before I'll take it under advisement, take a closer look, just to exactly why and what he needs to be doing or wants to be doing in the months ahead.
At a bare minimum, Judge, he needs to be able to talk about the case on his social media. He needs to be able to talk about the case to other people, not to
This current pending case.
Correct. Not to co-defendants, not to witnesses. I agree with that. That's not the objection here. With the exception of contact with the president for work-related purposes, not this case.
All right, Mr. Wade, last words.
We submitted, Judge. I think the court is the idea.
All right, well, I'll have something together, and I'll say that, as I indicated at the hearing, it did give me some pause that, as worded, and now it's, I think, even more potentially clear that Mr. Floyd's ability to even comment on the 2024 election is essentially prohibited by this bond order, and I don't see that as a necessary restriction to bond in this case. So at a minimum, I was willing to modify that. I do not believe direct contact is going to be impacted, but perhaps there can be some limitations on indirect contact that does not concern the case whatsoever. But I will work on that language. All other provisions, none having been challenged, would remain in place. So this, I think, I was provided to me in a PDF form. I think it was prepared by the state. If y'all happen to have it in a Word document, if you could send that over to me. Okay, anything else concerning Mr. Floyd that we should take up this morning? Let me start with the state.
Not for the state.
Okay, Mr. Kuchera. All right, thank you all.
Thank you.
Let's go off the record just for a moment. I think we counsel for Mr. Meadows, right? We didn't have it scheduled till 1, but I didn't think this was going to take more than a couple minutes. If you just want to go ahead, the state can stick around. We can knock that out. Yeah, yeah. Let's take 5, and then we'll reconvene on the motion with Mr. Meadows.
Judge, this is, just for the record, this is not.
Well, we're not on the record yet.
Oh, I'm sorry.
But if you just, as a matter of housekeeping, we're talking about the motion for production of documents for Meadows.
Yes, sir.
Is that your question?
It is, but.
Okay,
I was just.
we can wait. Good to go. Okay, we're back on the record, 20, good to go. Okay, we're back on the record, 23 SC 188947. This is going to be State versus Mark Meadows. Defense counsel, if you could identify yourself for the record, and if your client has waived his presence. All right, thank you, Mr. Durham. So we are here, I scheduled this, I don't think it'd be too lengthy of a discussion. It was more just an issue of logistics in my mind. But we have a motion filed, I believe it was February 5th, for a court order for production of documents. And, well, Mr. Wade maybe had some preliminaries he wanted to raise.
Well, we're just gonna sort of, if we could short circuit it just by saying this is not something that the state opposes.
Sure. If the state wants to be here or not, that's fine. Like I said, it's more an issue of logistics. Mr. Meadows, this was my hang up, is you've asked for a court order, and procedurally, why isn't a subpoena the actual route we want to go here? Isn't that actually what happened in Beaufort? It was a subpoena that was fought by the DOJ?
The subpoena was not, I don't know if it was fought by the DOJ or not.
Or TUI regulations were.
Because what the state moved to quash the subpoena, which was granted.
Sure.
He gets convicted, and the court overturns it, and in doing so, they establish the procedure, I believe,
Right.
under the Beaufort case.
So I guess my question would be, instead of a motion for court order, why not just give me a petition for subpoena under the Uniform Act?
So not sure if that applies, and I've referenced that in my motion. And there is no case reported in the DC Circuit Court addressing the issue whether or not you can use the Uniform Act to compel the production of documents. Georgia allows it, and we did.
To compel the production of documents
Not just
because of a federal entity, or just the production of documents generally?
Not just the Uniform Act specifically talks about the presence of a witness, doesn't reference whether or not that witness can be forced to bring documents, and certainly doesn't reference whether or not just a subpoena ducis tecum is sufficient. And so we did quite a bit of research, not saying that it was completely exhaustive, but just to make sure, I looked at the National Association of Attorney Generals, and they had just sort of a survey. When it got to DC, it said unknown. That's our first issue. The second issue is, under that analysis, there are other issues that come up that don't and could be problematic for the ultimate issue, which is Mr. Miller's due process rights, confrontation rights under the Constitution.
Yeah, and I agree with you that that might be a discussion on down the road, and I'm certainly willing to entertain those. Seems like they're premature. First, we've just got to get through this procedural logistical issue, right?
I have no problem, preparing it as if it is underneath the Uniform Act. I don't know that, I mean, the Uniform Act was in existence at the time of Buford. And there was an issue with regards to, you know, they, I believe, attempted to serve a subpoena on a DEA agent in Georgia. And one of the objections from the Department of Justice, I guess via the district attorney's office that was objecting to the subpoena was, even if you didn't follow TUI, the person that you subpoenaed doesn't have those records. And the Georgia Court of Appeals said, don't really want to hear it. The proper procedure is, and the court can get involved, and that was the suggestion in Buford. The proper procedure is the court issues an order to the Department of Justice, to the National Archives, and then if there is an objection at a proper forum on behalf of the National Archives or the Department of Justice, then that can be litigated. But having said that, Your Honor, we can follow the Uniform Act. I just don't know that it applies. And I also think that there are other sort of procedural hurdles within the Uniform Act that may be an issue addressed that don't necessarily relate to my client's due process rights.
Sure.
But again,
And I see the point you make in Buford. It says the court should order its disclosure,
that's right.
but I think it says that's conditioned on if the Attorney General refuses.
Right, but the
Right.
first step was this sort of, I mean, the Court of Appeals in the paragraph before
Yeah.
talks about the court, not the defendant, asking the Attorney General to hand it over. And if they say no, then the court shall order.
Can you point that to me again? I'm not finding that.
Yeah, so I believe it's, I'm about halfway down on page 138 of 282 Southeastern 2nd, 134.
The appropriate and dignified approach would be to move the Attorney General.
Yeah.
Yeah. I mean, it just raises more questions than answers to
It
me.
does.
It's how do I serve an order upon the Attorney General? Is the Fulton County Sheriff supposed to go do that for me? And how do you effectuate service on the Attorney General's? I mean, none of that is specified in code like subpoenas are in the Uniform Act.
Right. You know, there's in multiple ways.
What about
Cases.
what about serving the Northern District if it's or some other district? Would that be considered serving main justice?
I would anticipate that they would object to that, but I mean, that is one way. Also, National Archives has an office in Georgia.
Okay.
That wouldn't prevent the court from issuing an order and serving upon the U.S. Attorney as well as the National Archives. But I would suggest that a courtesy copy also be provided to
Sure.
to Main Justice as well as the National Archives in D.C. But, Your Honor, if you want us to follow the Uniform Act to start off with, I'm happy to do it. I mean, I would assume that we would, you know, similar to what has been filed in the past. I saw some of the certifications that were made and the orders that you've provided. I would assume that you would sign that certification. We would then take it to the district, you know, the district court state side of DC, and then they would have a materiality hearing, which doesn't just include materiality. It's going to include, do we even have under the Uniform Act the ability to make an executive department produce documents without a witness down in Georgia? That's the issue.
Do you anticipate those same concerns with the archives? Or is that just more ministerial?
Oh, I think the Department of Justice is probably going to represent the
Okay.
National Archives, and I would imagine they're going to have similar. I would imagine the National Archives is going to go, I mean, not all of this stuff has been indexed. I mean, what are we supposed to do? The response to that is going to be, well, apparently didn't have a problem handing it over to the special counsel.
Sure. Okay. Well, obviously state's not opposing or taking any kind of position on this, but any enlightenment to offer from the state? I know that there have been several instances of the Uniform Act used throughout the history of this case. Were any of those used to compel the production of documents?
Judge, not to this point, no, not documents, just witnesses.
Okay.
So again, in Georgia law, Uniform Act does apply to the production of documents, but I believe there's a Court of Appeals case that says ancillary to you actually bringing a witness down here. And so, yes, it can compel.
Oh, okay. So wait, I thought you were telling me that just the act and the statute itself doesn't apply to production of documents.
Well, the plain reading of the statute does not.
Okay.
But in Georgia law, there's Court of Appeals decisions that say, yes, of course, this means you can also compel production. But so there's really three groups: compel a witness and documents, compel just documents. And there is a significant number of courts that have states that have decided compel documents is included. Georgia is not among those. It is in the, yes, compel documents, but you also have to have a witness.
Do we get around this? Again, I'm open to getting this to a decision on the merits.
Absolutely.
So what if this hearing on this motion was reset for a date certain 2 to 3 months from now? And then your subpoenas for a witness to appear with these documents in hand. Does that solve the procedural hurdle?
It is. I just don't know, because we haven't been able to find a DC circuit case addressing this issue, whether or not that is going to be a hurdle where they say, on its face, the Uniform Act doesn't talk about production of documents. I just, we could be back in the same place, and that's fine.
Sure.
But
Well, why don't we start with the
Uniform
easiest one first? I would say the easiest one would be avoiding the Uniform Act entirely, and you just do a subpoena within the state of Georgia on the entities you say maybe legally responsible for producing it. And that's something you draw up on your own, you sign on your own, and then I suppose we might have a motion to quash of some type, or they remove it, or we go from there, right?
Yeah.
And simultaneously, if you want to try the Uniform Act as well, that's certainly something you can present and go both uniform and the regular subpoena process.
Okay.
We'll see what road
This is
lies ahead.
certainly a first of its kind case in many ways, and this is one of the ways.
An issue of first impression. It's not the last or first time we've heard that.
Right.
All right. Anything else that you want to present on this one?
No, Your Honor.
Okay. Since you're here, I know you filed some other motions on February 5th, just as a matter of housekeeping. Were those ones that you wanted to schedule at some point for argument?
So I think as it relates to the Supremacy Clause immunity, we're entitled to a hearing. And we outlined that. I mean, there is no Georgia case addressing Supremacy Clause immunity by a Georgia court. But other immunity.
When you say you're entitled to a hearing, you mean an evidentiary hearing?
Evidentiary hearing. That's part of the reason why we're seeking these documents, because we believe they are of utmost importance as it relates to whether or not Mr. Meadows was in his official capacity, and that these have a nexus to his official acts.
Okay. And so I think we'd emailed this out this morning, but was the state planning to respond in writing to any of the February 5th motions filed by Mr. Meadows?
Yes, Judge.
All right. Well, if we could include a provision in there again, they're addressing whether you believe an evidentiary hearing is required on these issues of immunity and supremacy. All right.
Do we know when that response is going to be?
Great question.
Judge, we would take any guidance from the court on when you foresee scheduling some of these things. We've got, I think, 20-something pending defense motions. So we've haven't really dug into our timeline. We'd ask if the court can give some guidance to let us know when we should get those in.
Well, what I'll keep doing is letting you know what days I have available. And as soon as they're ready, meaning if the state wants to file a response that's been filed, then we'll schedule it. I know there are a lot of moving targets here, and I'm trying to keep track of them all. So I know we'd identified some dates the last week of February. If you think any of those you'd be able to narrow down, we can do that.
And Judge, a thought might be on this motion in particular, since council's saying that they need some of these documents that they've subpoenaed. Maybe we set this one in particular out 2 or 3 months, like the hearing on the motion itself. And then they can, go through whatever process they need to get those documents, and that would give the state plenty of time to respond to Mr. Meadows' motion.
Well, I think it's impractical to think that we're going to get what we've asked for, which are, the distinction between everybody else and Mr. Meadows and possibly former President Trump is, when he leaves office on January 20th of 2021, he leaves behind all of his official records, which is with the National Archives. That's the typical, let's just say, white collar case, fraud case, where the government comes in, they do a search warrant, they image all these computers, they do this, they do that, and then they hand over discovery, which is basically what the personal records of the individual. That's not what we have here. And so, the state has, in our opinion, cherry picked stuff that came out of the January 6th committee, taking out, instance here without telling the full story, because January 6th committee didn't issue all of the records that it obtained. And we heard from government counsel, a few hearings ago, that all they did was obtain that from the website. And so that misses out on his phone records, his
So,
texts.
what I'm hearing is your arguments on materiality, and I think we may have to cross that path.
Understood. but
According to the
my-
Buford case, right?
Right, but understood. But my initial issue was, I think what the state said.
Scheduling it for a hearing.
Correct. But combined with that was, why didn't he just have the documents produced to the hearing? Are you kidding me? We're talking about terabytes of information, likely.
Sure.
Just to be clear, the statement was that gives a date where they could be subpoenaed to.
That's right.
Could start the process. If it has to be moved, it has.
Have you had a chance to take a position on whether you think it does require an evidentiary hearing? Any of these issues?
The state, no, Judge, not yet.
Okay.
I can tell you, I think it's pretty basic. There's Georgia case law as it relates to just other immunities and the requirement of a pretrial hearing.
Okay. We'll take a look. And so.
But to your point, Your Honor, what I would suggest, based on what you suggested to me, which is if we go the Uniform Act route or the subpoena route, that we issue a date certain based on Your Honor just telling what that date certain would be.
So that is what you're asking for?
Yes.
Okay.
2 or 3 months out is what I believe you said.
All right. And that would be for?
Just the production. We can show up for a hearing.
Right, that hearing, but the hearing is on what exactly?
Them showing up with the documents.
Oh, yeah, right. But what's the hearing, the purpose of the hearing? What are we hearing
A
argument on?
Preliminary hearing of the immunity hearing.
Community hearing. All right.
And Judge, you've mentioned the materiality issue. We felt it was narrowly tailored. I would understand that somebody could disagree, but I'm happy to discuss any of those requests as well. But
It sounds like that's what you would put in an outline in your Uniform Act petition.
Yep.
And the state is not opposed, so I'll read that. And if it looks in order, I'll sign it.
Do you have a time that you want us to submit that?
How much time do you need?
A couple of weeks.
All right, let's, so we'll say, what is a couple of weeks? What's 2 weeks from today? Again, I don't have my calendar present. Flying blind.
I am usually a day off, so I'm not really sure.
27th.
27th.
Okay. So I'll keep an eye out for that on the 27th.
Thanks, Judge.
Thank you, sir. Okay, I think we need to take a break and maybe back around like 1:15 for the last thing we had calendared for today. Thank you all. Off the record.
Yeah, sorry to interrupt. We're all reporters from different outlets. Just curious, curious of what this 115 is gonna be about.
The state filed a motion to rescan the indictment.
Okay,
And, I responded, and the premise of it is that the OCR software changed the numbering of the enumerated acts in the indictment.
got it.
And my position was, wow, that would be a miracle if that happened. And so, that's what it's like.
Okay, great. Thank you. Thanks so much, Eric.
All right.
Okay.
And that pleading, I don't know if you guys have seen, but have those pleadings come across, the motion will be scanned, was that?
No,
weeks ago?
no, that means the hack has just disrupted everything.
Well, I'll, depending on how much it is, I'll explain. Okay, thank you.
All right.
But I thought you were cool.
No, that's
Yeah,
it. We
that's
keep
it.
getting surprised by yours.
Yeah.
I have to go back to my office and write brief. Let's do tomorrow. So,
Is your client coming on Thursday?
no, if I you, I'll be there. Yeah, we joined the motion.
Yeah. Who do you work for? Writers. Oh, cool. Up here. Look.
Thank you, Eric.
Hey.
Good to go. Back on the record with 23 SC 1888947, this time State versus Jeffrey Clark. And we noticed this for the state's motion to rescan the indictment filed February 1st. And Mr. Clark was the only defendant who objected. And subsequently, I understand there was a subpoena issued by Mr. Clark to the court of clerk on this issue. And the clerk through Fulton County has filed a motion to quash on that. And so on behalf of Fulton County, Mr. Alexis, I believe, we have you appearing for the record. You don't have to present, I'm just getting introductions.
No, Judge, I didn't, I don't, did you ask me if I sent an entry of appearance?
No, did you file the motion to quash?
Alexis on behalf of the clerk.
Thank you, sir. And on behalf of the defendant, Mr. Clark.
Harry McDougall, Your Honor, and to the extent necessary, Mr. Clark has waived his appearance for this hearing.
All right. Thank you, Mr. McDougald. I just want to dive right into this, Mr. McDougald. I understand you were able to serve the subpoena on the court of clerk because she made herself available to you last week, answered some questions for you. What possible relevance does this have to this case?
Your Honor, I'll approach the lectern. I spoke to the clerk because I wanted to look at the original indictment and try to understand better how this might have happened. And I gave her a subpoena for documents that I thought might shed light on that. They've asked for more time to produce those documents, and I have absolutely no problem with giving them as much time as they need. But just before Your Honor came out, I had an opportunity to speak with counsel for the prosecution about their experience, and combining that with some of what the clerk told me on Friday, it seems that this indictment is not the only indictment in which an error of a similar nature following a similar pattern has occurred. They can describe that better than I can, and they have assured me that the original does not have any of these errors. I filed our response because when I saw the statement that the OCR software had made these errors, I was extremely skeptical based on my many years of experience in looking at millions of OCR documents, never having encountered any such error. And it's just fundamentally not how OCR software works. But evidently, there is a reasonable basis to believe that the software made this error. Now, if that happened, okay, the county has paid Tyler Technologies a lot of money for a system that should not be making errors of this nature. To have 4 errors of this nature in one document is like winning the Powerball 4 times in a row. It indicates, if that's the case, if it was the software is defective. And it needs to be straightened out because it will affect cases other than this one, as Mr. Wooten told me a moment ago. So my suggestion would be, if the court would entertain it, that we give the clerk as much time as they might need to prepare the documents, compile the documents, and that we bring somebody from Tyler Technologies into the courtroom to explain if their software did this in this case, and if it's doing it in other cases.
Okay, so I think that still gets back to the original point of to what end? You know, when my printer stops working in the back, do we need to investigate that? What does that have to do with this indictment and the actual legal material things we have to decide for this case?
There's law that clerical errors in an indictment are immaterial and don't give rise to a defense.
Thank you. And I could strike them right now regardless of how they happened.
Correct.
And fix them.
Correct. But, you know, I get a motion from the state. It says something that based on 25 years of working with documents, I don't think it could possibly be correct. I consult with experts. They don't think it could be correct either. Now, did I bring an expert? No, I did not, because what's going on is happening in a Tyler Technologies black box that no outside expert has visibility into. But either the software is bad and it's making this mistake, or something else is happening, I have no idea what. But if the software is bad, that's a serious problem for the county and for the clerk. Imagine the clerk's consternation, given her statutory responsibilities, that the system that they've paid so much money to have is making errors of this nature. And it may not matter in this case, but it's going to matter in some case. Verdicts and judgments, or any document that gets scanned in, would be susceptible to errors of this nature. But, and I emphasize it's just absolutely unheard of for OCR software to change the image that it's interpreting. And I can show that to you in this particular document, if you're interested. But it's never seen it, never heard of it. Always the first time. But if that's happening, they need to come in here and explain it, talking about Tyler. So thank you, Judge.
Well, I'll say this, if you say and this is just my reaction to that, is when you say they need to come in here, I don't see that there is a legal requirement that they need to do that, because there's nothing that impacts this case or the indictment or all the things we have to get through. I think as a concerned citizen, you might raise some very valid points. I think that with all the things that we could fix here in Fulton County, improve upon, this may be one of them. But as it relates to legal issues for us to decide today, I just see absolutely nothing.
Well, Your Honor, I would say in response, respectfully, that the legal significance, if any, depends on how this came about. If it's the software, I concede the point. But if it's not the software, then what happened? And it might have legal significance at that point. I don't know whether it would or not. And I want to be clear about something. I'm not accusing anybody in the clerk's office or in the DA's office of misrepresenting anything. Ms. Alexander was perfectly charming to me, perfectly accommodating. I take counsel at their word. I take her at her word. This is what they're being told, that the software is doing this. And it's, oh, really? That just doesn't seem possible. But if the court thinks we don't need to worry about it, then I'm said my piece and we'll move on.
Well, I'll just say, I mean, we're talking about an issue of numbering here. I think it was 3 or 4 or 5 numberings that are off or repetitive.
Mhm.
If you had brought something that said actual words were changed, maybe that would look more nefarious. But I just, I don't see it. And when it comes to the motion to quash, I think just on the baseline hurdle of relevance, that the indictment, or excuse me, the subpoena, that there is no legal relevance here, and I will grant the motion for quash. When it comes to the state's motion itself, I'll turn to the state. Was there anything the state wanted to present, evidence or otherwise?
No, Your Honor. Grant Rood on behalf of the state. And we think it's a relatively simple ask. Go down to the clerk's office. If Mr. McDougald or any counsel for co-defendants want to join, we don't oppose that. Look at the physical copy that was scanned in, compare it, and if the numbers are sequential like we believe they are, then rescan it. If there is an error in the printed copy that was handed up before the court, then we'll live with that.
Mr. McDougald, were you given a copy of what the clerk told you was the original indictment, or shown a copy of it?
Madam Clerk showed it to me. I did not spend a lot of time studying the document because I didn't want to take up her time watching me do that. But she was perfectly accommodating to me, Your Honor.
All right. Well, I appreciate that observation, Mr. McDougald.
Your Honor, I mean, if the system is did that before, how do we know it won't do it again? Has it been fixed?
And it may, and we'll just have to keep dealing with it. But in terms of, I just don't feel like going down this rabbit hole is the best use of all our time. And I think there's many more things that we can spend our time looking into, especially when it comes to this case.
Perfectly understood, Your Honor. Thank you for, so I do have one issue.
Sure. Let me clean this one up though. Mr. Rood, was there anything else factually or anything else you wanted to have on the record as it relates to this issue?
Not factually, Your Honor. I mean, we've looked at our Word version that we printed out, took to the grand jury, and these numbers are correct. As we printed them out, 11, 12, 13, 14. There was no duplicates. So that's why we believe that the version that was scanned in is correct, and that I don't know what software they were using. It was just an error. And I've heard of OCR errors before, but factually, that's all we're asking. We're just, like I said, we're asking for Your Honor to go and look at it yourself, make the examination.
Okay.
So,
Well, I'll just note for the record that the issue had already been brought to my attention shortly after the return of the indictment. If it was in August, it was in September. And the clerk, Miss Alexander, brought me a physical copy of the indictment, and I reviewed it, and I saw the misnumbering. And so that is the representation that's been provided me. Again, it's a completely immaterial aspect of it. I see this more as complete housekeeping. And whether it's a rescanning or a correction under the case law, I'll grant the state's motion on that point.
All right.
All right, and written order to follow.
Fair enough. Thank you, Your Honor.
Mr. McDougall, you mentioned you might have something else
I
you
have
want to
one other,
address.
one other item,
Okay,
which is that one of our filings on February 5th was rejected by the power system because the date above the signature block had the year 2244, had extra 4 on there.
you just need to refile it.
I did, and it got file stamped for the 12th. And so that's here. The file stamp was on the 12th, and my anxiety was that the deadline was the 5th.
I understand. We've been dealing with a lot there. What's the title of the motion? Has it already gone through?
It has gone through, and I have the email chains and the cover sheet, if I can hand that up so we can identify what I'm talking about.
Sure. Well, I mean, it's fine. If you just tell me what the title is, we might have already. Okay.
It's called Jeffrey B. Clark's General Demur, plea and bar, and motion to quash based on federal supremacy and immunity and lack of subject matter jurisdiction.
Okay, understood.
And I spoke to
noted.
counsel about it, and they may need to go back to their office, but I don't believe they're opposed.
Okay, no, understood. And I think that, well, I'll just have state's position on the record then.
Yes, Judge. I believe we received the document
Right.
on the deadline, so we have no objection. We're
And I think we would have also received the courtesy copy.
right.
So, no issues of timeliness there. Appreciate you though being wary of that. Anything else?
I know, Your Honor. Thank you very much.
Okay. Thank you all. We're off the record.
Judge.
Have a good day.
All right, Mr. Rude, do the same.
From Fulton County.
Pardon me?
It's a little different.
Welcome to Fulton County Elections.
Your words, not mine.
Hey, right, I was on the election.
State election?
No, it's Fulton County.
Okay, I didn't know.
Yeah. First, I was an attorney for the boards, and then I was on the boards. It's 8 years I've worked in the field, but it was in the 2003 there for the first Obama election and the second one. So,
I'm sure you got stories.
I did.
See,
She's smaller than I. Yeah. Yeah. I probably got 25,000. Yeah, it's
Appreciate it.
I appreciate that, thank you. He says Aisha, right?
Alyssa.
Alyssa, sorry. I get it.
That's pretty brief.
Yeah.
3 down, 1 to go.
No, Jimmy,
We have Hampton.
I thought that was.
No. No, this ain't have nothing to do with Trump. Okay.
Oh,